Turn on. I'm going to go grab my computer. Please take a copy for you and Michelle. Okay.
Thank you.
No worries.
Good evening. It is 5:34, and at this time, I'd like to call our special board meeting to order. Ms. Dooley, may we please have a roll call?
Yes. Spencer Anderson,
Present.
Maria Delgado,
Present.
Stephanie Jacobs,
Here.
Amy Levy,
Here.
Sean Levy, Megan Miller,
Present?
John Wong.
Here.
Okay, I show all board members present with the absence of Sean Levy.
Thank you very much. And at this time, would somebody like to make a motion to approve our agenda?
So moved.
Second.
Thank you. We have a motion by Amy Levy and a second by Mr. Anderson. All in favor, please say aye.
Aye.
Aye. Aye.
Aye.
Aye. Are there any opposed? All right, motion passes unanimously. At this time, I'd like to hand it over to Dr. Kieser and to Mr. Bukema and his team to assist us in our expulsion training. Thank you so much, everybody, for being here this evening.
Thank you, Board President Miller. So this evening we've set aside time to do our training for the board. And the training is going to be both training as well as discerning the process for the board to take over expulsion hearings. And so Rob Bukema and his associates, Sheila Tobani and Alana Loeffler, thank you. I apologize. I thought I had memorized. Are here this evening to walk through a slide deck as well as some handouts. So for those that are attending virtually, I will be running the slide deck for the slideshow, but you will mainly want to refer to the handout attachment that's in board docs. In part, we'll be going through the agenda in the front half and the attachments which is in the back half of the PDF. So with that, I will turn it over to Rob and his team.
Thanks so much, Dr. Kieser, and good to see everybody in person. Very unique, and we still have the masks, but now you get to see my face for a little while, and so that's good. And Sheila and Alana will jump up, and we'll try to make this as interactive as possible. We have plenty of time. We have good content, and we're looking forward to having a good dialogue with the board. And I'm hoping that those of you who are virtual will be able to hear us well and be able to interact with us as well. So, and as Dr. Kieser said, we'll have the slide deck, and so the outline is one thing, and that's kind of the bare bone structure of what we're going to go through. The attachments are pretty important because we have several examples, ones from the district and ones that we are suggesting perhaps as templates that we could use. And where there's differences, it's more a matter of taste rather than content, and we can explain that as we go along. And then we have some other attachments on special ed and some issues that come up on expulsion appeals, but we've got the ability to put together this presentation in a way where the board can feel like, okay, this is what we're going to be dealing with if we have to hear our first expulsion case. And it's interesting that the title says the board's role in expulsions, and I guess it's very simplistic, but it's critical. The board's the ultimate decision maker, and I think about this as with so many other issues, the board decides the outcome. And so from your perspective, the board has a critical role. Of course, the administration has a critical role in bringing the cases and making the recommendations, and obviously the parents have a very critical role to assist their children to navigate the process as well. So joining me in the training is Sheila Tobani and Alana Loeffler. I just want to say a couple of quick things because you haven't met them before, but Sheila joined us from the city attorney's office in Milwaukee, where she was assigned exclusively to represent the Milwaukee Public School Board. And she has great experience in dealing with a variety of school law issues, including representing the board's interest in expulsions before, and they have a hearing officer and many pupil issues and special ed matters. So we're really glad to have her. And Alana Leffler, you might know, she's done some work on special ed matters with Missy, who's here as well as a resource. And Alana's a partner in our firm. She was just made a partner and has extensive school law experience with districts in Wisconsin. She's been involved in a lot of expulsions and in districts throughout Wisconsin and has dealt with unique issues, especially with students with special education. And that's a key thing we're going to talk about is what happens with special ed kids, what's unique or what's different, how do we handle that, and what do we recommend, and then also dealing with a lot of other pupil services issues. So, and they're going to be taking a lot of the presentation. And frankly, it would be fun if we could all chime in, and you got 3 lawyers here, so I'm afraid we're going to probably have a lot to say, but we have 3 hours, just joking. I'm hoping that we can be very efficient. But what can you expect from us today? We're going to be providing training on all aspects of the expulsion process that the board's going to be involved in. And a lot of this has a statutory basis. And quickly, we're going to go through the notice, the hearing, the order, special ed issues, what happens on appeal, unique issues, and then I identified some other board concerns that I've heard from listening over the last couple of meetings, so that we'll be able to address those as well. And then in each key content area, there's going to be a pause for board discussion and board input, and that will take whatever direction you have in terms of making sure all of your questions are answered, and then also just getting comfortable with, okay, this is kind of the notice we're comfortable using, and the order, and if we have a script, what are we comfortable? And again, we're not going to get every word etched in stone tonight, but we'll get an idea from the board what you're comfortable with and what you want to do. So we're going to start with the statutory basis for expulsions, and this is purely a statutory process. And the reasons or the bases, the broad bases for expelling a student are contained in the statute. And in this situation, there's mostly may. The board may expel. That means they can or they can't. I mean, you're going to decide whether you do expel or not. And these are the situations where the board may expel. And it's interesting just to get these down. I mean, we're not going to read exactly from the outline, but you'll probably be familiar with, because several of you have been involved in hearing these cases and been involved in education, and so you're familiar with these standards. But so there's kind of 4 standards for may, and the first one is the student is guilty of repeated refusal or neglect to obey the rules, kind of like the progressive discipline in the student setting. Students who continually violate the rules sometimes are brought for expulsion because the volume of the repeated refusal to obey is so significant. I think from my experience, this is used as a very frequent expulsion basis. I also think that we talked about it as a team, and this is also sometimes a throw-in where people will put this as an additional basis for an expulsion when the real reason is a threat or some other conduct, and maybe that's associated with repeated refusal. So that's the number one basis. And then the second one is, and every word that's in this statute is important. The student knowingly conveyed or caused to be conveyed any threat or false information concerning an attempt or alleged attempt being made to destroy any school property by means of explosives. The simple explanation of this one is a bomb threat, but you can see the wording is very carefully selected, and any threat or false information, it doesn't have to be threatening language, it could be false information. And then interestingly, an attempt or alleged attempt being made to destroy any school property. That means they don't have to carry it out. They could just say, well, this is what I'm thinking about doing. And so each word's important. Again, this is sometimes happens. It's not very, very frequent. But This is where a lot of the school violence cases have come up, people who are threatening to take action. But this one focuses on property, doesn't focus on people. And so, yeah, it's not as simple as the bomb threat, but at least it's something that gives you a little bit of a basis to say, that's kind of the next area. Knowingly conveying or causing to be conveyed a threat or false information.
So I'm just going to interject quick. Did you want questions throughout, or do you want to?
Yeah, you
wait
could
until
ask
the end?
questions
Okay.
throughout, that'd be great.
Okay, so in that case, board members, if you have a question, just please put a question mark in the chat, and then I'll just interject as appropriate. Thank you so much for allowing that.
Yep, and then the other is, okay, Amy, let's,
Thank you. I know that it specifically says explosives, which you detailed as bomb threats. But what about other incidences of that magnitude? And specifically what I'm thinking is like school shooting. Is it limited to bomb threat for some reason? I know you said every word in there is kind of important.
yeah, that's a great question. You probably could use that statute as a basis for that. I think the other is that the ones we're going to get into in a minute are endangering property, health, or safety. And so those are probably a little bit more specifically relevant. And I think one of the things we're going to want to do with the board is make sure that when there's a recommendation, we want to make sure that the basis is appropriate. You know, the statute section is the right one, and that there's a good explanation of what the conduct is that the board would be concerned about or that the administration was concerned about. So, yeah, I think that in that situation with a shooting, I think C might be a little bit more appropriate, but sometimes B is used. Okay, so that moves us on to C, and that is the student engaged in conduct while at school or while under the supervision of a school authority which endanger the property, health, or safety of others. The two things there are the endangerment of property, health, or safety of others, and the other is at school or while under the supervision. Another key consideration, and that is most of these situations are going to be much clearer if the incident took place at school. Selling drugs, violence of some sort, some type of a school shooting threat. Also, under the supervision, the thing that comes to mind there are athletic activities, extracurricular events, school-sponsored events, field trips. And again, this is where the lawyer in us always looks and says, okay, how far does that extend? Anything that's school-sponsored or school-blessed is probably important. A lot of those are clear. I mean, if the teacher's involved or if a supervisor's involved, somebody who is a district employee, sometimes the district empowers volunteers to go, and those people then, if they're empowered or have a linkage to a formal board action, can also be under the authority. And so those are all areas where we have to look and say, okay, when did this happen? Where did it happen? How did it happen? And so at school or while under the supervision of a school authority. And then you can see that endangerment of property, which is vandalism of some sort, health. I think about drugs or alcohol abuse or some other type of situation which would impact the health of a person or the safety. The safety, I think, of more potentially criminal activity. And again, you could list those things, or use of force, those types of things. So I think those are readily understandable. Repeated refusal, kind of the bomb threat with explosives, and then this one is kind of would be one of the ones that would be used quite significantly with more misconduct-oriented situations at school or under the supervision. And I think you can understand that pretty clearly, and those words are fairly clear. And where they're not, it does take some interpretation to say, okay, is this under the supervision or not? And that usually you can get help with that, or as you get experience with these, you'll have a better understanding of when that is or when that isn't. Okay, and then D, the student engaged in conduct, and this is a long one, but it's a little bit daisy chain, but this is one where they're not at school or under the supervision of a school authority, okay? So I'll get to the specifics in a minute. But you're not at school or under the supervision, but the action a student takes endangers the property, health, or safety of others at school or under the supervision of a school authority. And here's some interesting caveats. Or endanger the property, health, safety of an employee. So this was, most of the others say of others, and maybe that's broad enough for employee, but here specifically it references an employee or school board member. And so a situation with a school board member might be a threat by a student to take some type of physical action or violence against a board member for a position they took. To me, that's one that comes to my mind. And that person may not be at school, or they might not be under the supervision when they take that action, but they are impacting a board member, or they're impacting an employee, or they're impacting somebody who is at school. Another one that our team was talking about would be the sale of drugs off of school property to predominantly the student body, impacting how students are performing or acting at school. And so there have been linkages where the activity was not on the school premises or while under the supervision, but it was impacting students in the district. And so you can see where it's a little bit harder to show cause, but you can see where the legislature had to identify these things in order to say, what happens if it's not at school or under the supervision, but it still has a negative impact on students, employees, school board. Interesting that it covers the school board too, because I think there's protection there for the school board. I hate to say it in this day and age where people are, making threats against multiple individuals sometimes. The school board's protected there. Okay, so those are the four, and then I'm going to get to a fifth one in a minute. It's at the end. But those things are bases, and the board finds that the interest of the school demands the student's expulsion. And you're going to find that that's kind of a key phrase in expulsion lingo, and that is every time that you get together to hear a case, every time you are deciding on a case, you're going to determine what's in the best interest, do the interests of the school demand the student's expulsion. And we also were talking about that, and our team was saying, if those are questions the board's going to wrestle with throughout the hearing and especially at deliberation, and those are things they're going to have in front of you, that we have a script or some guidelines and that's in there, so that every time you have one of these cases, you're going to wrestle with, do the interests of the school demand the student's expulsion? And then a couple of other things. You must hold an expulsion hearing in order to expel a student. You can't do it in any other way, and so there has to be a hearing. That's statutory. And that sounds like obvious maybe, but I think it's important to know. In other words, you can't somehow by resolution, you have to have a hearing. You may expel a student until a maximum age of 21. And then there's this additional must, and that is mandatory expulsion for firearm. I think the board's familiar with this as well. It's really a subset of C and D, because you would say, well, a person brought a firearm to school and that endangered the safety or health or property of others. And so it's C, but then it says you must expel. And interesting about that is we did a little bit of review of that for the district, because Dr. Kieser said the board was looking for information about, okay, this is a must or a may. Are there situations where you have any discretion in that regard? And again, this is not very well developed territory, but for the most part, it's a must, and that's how DPI looks at it. But there are exceptions. So I don't want to sit here and say there aren't exceptions. There's exceptions, and the way that we understand the exceptions would be for a very good reason, and that reason would have to be articulated and put in writing by the board, and they would have to review that or send that to DPI. DPI would be reviewing those situations. And so there's some kind of an accountability there. But there are situations, and obviously we can work through those if this ever comes up, but it's generally speaking a must, and then there are very limited circumstances where you may be able to make an exception. But then you're going to have to be accountable to DPI for that.
Thank you so much. Board Member Wong?
The definition of firearms, is that going to be, I mean, for the statute, I'm assuming that means an actual gun itself?
Yes.
Not
Yeah,
a
and
not a
that's-
BB gun or
Right.
a rubber pistol or something like that?
Although a lot of districts have reacted very strongly about that. And, but yes, there's a specific definition about a firearm in there. And, yes. And you know, what's interesting, we were talking about this on the way over too, is that I'm hoping that we can answer every one of the board's questions, but this will be interesting too, because as we have a case, just say we have our first case, and if we're there to assist the board, you know, we'll be able to work through these things and say, okay, you know, let's make sure that we make a good decision based on all the information we have. So right now, there's a very clear definition what a firearm is and what it isn't. You know what I mean? And the board would have that information there.
Thank you so much for that.
So that's my first introductory section, and then we're going to, and I think that provides a basis that you can see how expulsions, the content of expulsions. Sheila's going to come up and walk through the notice and also the hearing and the order, and we're just going to talk through what's expected or statutorily required with each one, and then we're going to look at the examples together. Okay?
Thanks so much. Board Member Levy?
Really quick, I just need clarification. If you have to have a hearing in order to expel a student, and if a student brings a firearm to school, they must be expelled. What is the purpose of the hearing in that case? Is it strictly performative? Is there just certain documentation requirements? If you could walk me through that briefly.
That's a great question. Yes, there's a statutory requirement that you have a hearing so that you have a record, so that there's an appeal right. That has a lot to do with what the board's required to do by statute, and that is have a hearing. It's a lot to do with what the rights the student gets. You know what I mean? To have a record, have the ability to hear the evidence, have the ability to make an appeal to DPI. And so in order to be able to do all these things, you have to have that record established.
So it's my understanding that the only way DPI would repeal or kind of reverse the judgment of a board if it was a procedural misstep, like we missed something in procedure. Is that the case with a mandatory expulsion like a firearm? How is that?
Yeah, I mean, it would be, you're probably going to have a hard time with an appeal unless the board thought it was one type of weapon or there's some type of technicality there. You know, I mean, I can envision places where there might be a technicality, but if it was a firearm and it met the definition, you know, then I guess if the board found, just say the board found a circumstance where they could find there was a reason or an excuse or something, they would have to basically talk to DPI about that. But generally, they would have to pretty much follow through and expel.
And I just was going to add, there's one case in my section later where I talk about some expulsion appeal decisions, and a mistaken determination that it was a firearm is one of the bases why one got overturned. So I'll talk to you guys about that too.
Thank you so much.
Okay, Sheila's going to take over now.
Thanks, Rob. All right. So, as Rob was mentioning, right, authority, and with authority comes a lot of responsibility. The reason why the notice is important is because statutorily there is a procedure to follow. And what that statute outlines is timelines, the content of the notice, right? If you're accusing someone of something, we always hear those great words of due process. And so it's the same situation. Frame that in for a student you're bringing to the table. Administration is saying something happened. They need to know what they're being accused of. So all the components that Rob talked about earlier for your authority to expel a student, that's going to be your basis in the expulsion. And when I say your, I mean we're partnering here, right? There's administration that has to follow their process, and we'll go over that. And then the board also makes sure that, okay, is administration bringing these correct things to the table so that our authority is in play here. One of the items that Rob mentioned earlier too was the repeated refusal portion. That's important in a notice, and Alana will go over this as one of the examples, is because the notice requires anything that you're going to bring to the table at the hearing, you got to let the person know, you got to let the student know. And so if it is repeated refusals, we want to make sure that each one of those incidents that administration is bringing to the table, the kid's on notice for that. Again, like I said, there's a bunch of examples Alana will go through, and it'll speak to why procedure is important, especially not only for the board's duties and looking out for the student and making sure the school district is following the right process, but also for appeals, right? This is all part of the record. This is what DPI is going to rely on to make sure the school district did their job correctly. So if you see the attachments, there are some examples. We have attachment number 1, which I believe is your very own. So the School District of Beloit. And here's an example, right? It lays out specific things in the statute. You want to have a reference, right? This is the authority that the board's relying on. You want to have time, place, where they need to show up, who to communicate with, any requests that are needing to be made, the alleged action. There's also information about, what can happen, how the process is going to play out during that hearing, and what can come about from it. All these components, and this is a very good example that the school district has, it hits on all the components that are needed statutorily for a notice. If you look at the other, there's just examples that we've provided that we've done before. It's really about the presentation of information, right, on a notice. So you can have it in paragraph form, very concise to the point of what happened with the student, or you also have the option of kind of you can do no wrong because there are all these statutory reasons for why you expel a student. We've laid them all out, and then you can check mark which one falls within this category. And so it kind of also gives, whoever's looking at this notice, whether it be the parent, whether it be the board, they get that background information of your authority, right? It's one thing to just say, here's the statute, go look it up. It's another thing to also provide that information about the statute.
Can I ask a quick question?
Sure.
I'm sorry to interrupt. Thank you. This is all really helpful. Okay, so I'm looking at just like this very first point. Can you clarify whose responsibility is it to provide the 5 days written notice? Does that fall to the board or to the administration? And then I have a follow-up question.
So it will be administration.
Administration, okay.
And I should have opened with that this is just, we're showing you so you have exposure and you understand how the standards that the school district is held to.
Perfect. No, and then I'm just curious, is it so to what extent is it then the district administration's responsibility to ensure access, if the student is bilingual or if, you know what I'm saying,
Sure.
or properly gendering the student, how
Sure.
does and then making sure that, where does the burden go toward having the correct address? Mm-hmm. Could you speak to that a little bit?
Sure. So usually that's going to be, and I don't want to overstep on what administration already does, but usually it's a combination. You'll have someone in pupil services. They're going to be the ones that get all the information. They're going to be basically the point person to call. Hey, what's the procedure? I've never been through this before. Hi, do I get a chance to speak? Is there anything I need to bring for my kids? Can I have an attorney? All those basic questions for a parent or a student, there should be a point person with administration. And I'm getting a nod, so I think that is how things are handled.
Thanks for clarifying that. And it looks like so we've got a couple of people in the queue here, so I'm going to go to Dr. Kieser, followed by Vice President Levy, followed by Amy Levy.
Okay, appreciate it. So my question was just in reference for board members in the attachments. The first example is a letter that we currently use. And then right behind that, after it says the administration's recommendation, there is a notice of pupil expulsion hearing template that Rob and his team have provided as a counter. So I just wanted to make that clarification as Sheila was talking about the 2 different notices. That's where they are. They're just one after the other. And to Sheila's point, currently please correct me, Ms. Beavers, if I misspeak, but we have our pre-expulsion process, if it gets forwarded to a recommendation to expulsion, at that point, we sit down and talk with the family and the student about all of the pieces that Sheila had talked about in terms of what to expect, what will be coming in the mail, and now we are in the process of learning what they can expect when they come before the board, and the fact that there will be information presented in regards to it, that the board will be asking questions of the administration, the board will be asking questions of them as the student and the family or guardian, questions of them, and walking through that process so that there is understanding. And if there are accommodations that need to be made, we talk about that at that time before the notice is even mailed out.
And could I also clarify a couple things in response to the questions? The content of both of the notices, the one the district is used and the one that we're suggesting, are relatively the same. It's more of a matter of style or approach. And also, we found success with having every piece of information possible, including all the statutory options, so that the administration can simply say, this is the one that applies, or these are the two that apply, and then the student can see what we're talking about, because it's much more user-friendly to have the statutes laid out rather than to get an attachment with a huge statute that's hard to read. And so a lot of it is just how it's laid out. And again, there's absolutely no criticism of what's being done. It just has to do with what it's a best practice and what we're more comfortable with over time. And the other is that the administration might be responsible now, but as the board getting involved, it's a joint ownership. I mean, the board's going to want to make sure that the notice is correct. And so that's where, there's going to be some learning, because there's probably going to have to be more ownership saying, okay, who's taking care of the notice, who's going to do that at the district level, and who's going to make sure it's right. And I think one of the things that we could do early on is make sure that we assist. This is where, just with what Board Member Levy was saying, you don't want a technicality. This is the time when you get all your technicalities correct. I mean, so that you don't have a problem down the road saying you had a flawed notice, because that's an automatic problem. I mean, and so we should be able to get the notice right. We should be able to get that type of thing correct and appropriate for the parent, student, and the board.
And later on, we'll talk about, your options and what you feel comfortable in the board's counsel's role during the hearing. And that is a service we can absolutely provide too. Like, here are the check marks. Let's make sure procedurally everything is good to go, start the hearing, and cover all grounds for sure.
Thank you very much. Really appreciate it. Vice President Levy?
Right, so I'm staying on the slide that we're on, the 5 days written notice of expulsion hearing sent to the student's parent. So my assumption is that if a student is going to an expulsion hearing, they've already received a 5-day out-of-school suspension. So that is notice of suspension that has gone forward. And then now we're talking about the notice of expulsion that is going forward.
Correct, yes.
Right. So the administration suspends students, and they send that notice. And then if our process in the district is that something that's possibly expellable is going to go to an administrative hearing, then that is our administration handling that also. When we get to B, the administration would, like I said, whether it's a listing of all things that are expellable, but specifically what the student did, that is going to be listed so they understand what their expulsion hearing is about. And then when it gets to that B discussion of who earns the notice process, yes, it's a hearing conducted by the board, but my experiences and my preference for us as a board is that, yeah, that's something that I expect our administration to handle, to send that notice of expulsion out, and that things are procedurally correct. Because if things were not procedurally correct, that would be a violation. If things were not procedurally correct, or notice and things like that did not get done, those would be professional mistakes and errors.
Absolutely.
Thank you very much, Vice President Levy. Board Member Levy, followed by Board Member Delgado.
So 2 questions. One, is there a confirmation of receipt with these? And my concern is if you have a student that it's mailed to the home address, that is no longer their home address, so they have no idea, and that's why they haven't responded. I wouldn't want that to be confused with, I got it and I don't have any questions, that's why I'm not reaching out. So one, do we require kind of a response after receipt? And then my second question is, I think that handling the notice would have to be a duty of the administration, because I don't see how a board member could check to make sure this is accurate without hearing information in advance of the case. You know what I mean?
Absolutely. I'll pass the buck for a moment because we all have different experiences with that. There's a variety of things, right? With confirmation, is it if you send it by mail, do you get the receipt, right? Signature that it's been mailed. Or if it's just a matter of you have your own procedure and process, right? We stamped it, we have a copy of it, we keep a copy of the envelope that goes out. There's a variety of different options, but I'll let others to speak to their experience as well.
And may I just add clarification before you jump in? If the administration could speak to what is currently happening, because if it's not broken, we may not need to fix anything, but I would just be curious as to what our confirmation of receipt process currently is.
Currently, the confirmation of address happens at the administrative hearing. And so when the parent is sitting with the administrative hearing officer, they confirm address and phone number, contact information there. It's not sent certified. I do know that. Like the hearing notice is not sent certified.
Okay, so, and the administration hearing happens before, that's when the
The
determination.
pre-expulsion hearing, yes.
Okay,
Yep.
perfect. Now, we send out notice for that, I'm assuming.
Correct.
So if we don't get a response, we assume they got it and they're not responding? Or if you don't get a response and there's a no-show, how is that handled?
If we don't get a response and there's a no-show, the hearing is still held without the family or the student present.
So we don't have a way of knowing?
I don't feel like I can say that with 100% certainty, though, that the hearing is held. It might be rescheduled. I don't feel like I can say that with confidence.
No, I appreciate your transparency. At some point in the very near future, I would like to understand if there's a no-show and we haven't had contact, do we assume they got it and they just didn't come? Do we assume they never got it? And in what ways do we follow up?
Yeah, I will look into that.
Thank you.
I would say that if there's a scheduling, usually if there's an expulsion hearing, you'd reach out to the parents to arrange the dates so there'd be communication. And also, the statute doesn't require return receipt requested, but usually there's a certificate of mailing so that it's clear that it was mailed out, because that's what the statute said. But best practice is to make sure the parent knows and is going to be attending, you know what I mean, and is aware of the notice.
Right, but if it's mailed out and it never got to the person it was mailed to, I just want to make sure that we're doing everything on our part to make sure it's fair for
Right.
all involved.
Yep.
Good. All right, thank you very much. Right, or no?
Just the second part, I don't, am I missing something? Because I don't understand how the board could be involved in confirming that the notice is correct without exposing ourselves to information that we shouldn't have ahead of time.
My comment was only that the board has to basically say, we want to make sure the notice gets sent out appropriately. I'm not saying substantively, I'm just saying it is a partnership in a way, because the board's going to be engaged in that process. You just want to make sure it's sent out properly. You know, I'm not saying substantively you would get into it. It's just saying that's got to be done.
Perfect. Thank you so much. We're going to go to Board Member Delgado, and then I'm going to let Board Member Jacobs go next since she hasn't spoken yet, and then I'll go back to Vice President Levy. Go ahead, please.
Okay, so my question is regarding that 5 days written notice, and I don't know, maybe I just got confused when Vice President Levy was stating about, there's like a previous suspension that goes through. So when does that 5-day actually starts, or when does that go from, what time period does that take place in?
And I'm going to let administration correct me if they have a different process, but it's usually after the confirmation at the administrative, so they have the administrative hearing before, right? So we have the timeline of incident happened, administration gets together, considering expulsion, so sending the suspension notice, having the administrative hearing, confirming that, and what that allows administration to do is say, okay, now we're for sure sending it over to the board. That's when the notice goes out. Did you want to add to that?
That's
Yeah, oh, whoa, this is loud. Yeah, so then once the expulsion notice is sent out, you kind of check the date of that notice, and then you have to give 5 days lead time for the hearing so the family can prepare. So it can be more than 5 days away, just not less than 5 days away. And then going back to the suspension, once you send out the notice, so the max days of suspension is 5 days, but once you send out an expulsion notice, that extends to 15 days, so that gives you more time to schedule the hearing then.
Okay, that makes more sense. Thank you. And my second question is, how long does it normally take, like the whole process of the expulsion?
And that could vary
So-
by experience. Does administration want to speak to is there an average that you've noticed or your experience with the timelines?
The actual expulsion hearing itself, is that what you
No, like the process, because I know that there's like a lot of different timelines where things have to or must happen. So is there like it could be from 30 days to 60 days, is there like an average time period of that process?
There's not really an average, but there is a legal timeline attached to it, like they were saying, the 5 days, and then I believe without looking, is it 30?
For the decision.
15.
It-
Yeah,
Right.
15, yeah.
And then there's also, speaking of timelines, there's also the opportunity to sit down with the parent if there is any scheduling issues, right? To mutually agree that we're going to extend out past this date.
Great question, Board Member Delgado. Are you good? Okay. Board Member Jacobs, followed by Vice President Levy.
I was just getting back to the previous question. In my experience, and Rob, correct me if I'm wrong, so when I would take a student for an administrative hearing, if the parent or guardian chose not to show, the hearing was held, and the same was true for the expulsion. As long as the district has done due process by following any information that was given to us by that student's guardian/parent, we're in the clear. Even if they're no longer abiding at that address, whatever, that's the parent/guardian's responsibility to make sure current addresses are on file, correct?
That is correct, and I think there's a combination of factors, though, because I think the district can make sure that every effort's made to make sure the parents and the student are aware, and I think that's what's being said. But yes, I mean, there's a process in place that if you follow it, then that will stand up. I will also say that the process is very time-bound because a lot of times the administration will suspend the student right away after the activity occurs, and so that starts the clock. And so you can realize, and I think about this because I'm in tune with what the board's thinking, and that is if 5 days have already gone by and you have 10 more, and you need to have an expulsion hearing scheduled, then that's tough for I want to make sure the board recognizes that's an availability issue. You know what I mean? And then that's why we got to get a quorum together within the next 10 days. And again, I know Sheila mentioned that periodically there's a mutual waiver, but you don't want to use that as a normal course of business, because it really would be very difficult, because then you want to make sure that's in writing and that the parents understand that they're waiving their statutory timelines. And so it's better to try to comply with the 5 than the 10 days.
I personally think that it would be a mistake to give that option to the parent, because there's going to be times where there's going to be a lot of expulsions happening in a very And as you said, Rob, it's a very limited amount of time. And if we're going to try and reschedule times, I personally think that's a mistake. I think what is given to the parent is what should be accepted.
Thank you very much, Board Member Jacobs. Vice President Levy, followed by Board Member Anderson.
So there's several things that to come up. One, I think that some board members may be confused with, in the past, when board members would receive packets to review because the independent hearing officer had made a decision and they're coming days or 30 days after, that's a different timeline than what we will have. So there's not the review of materials if we're not receiving materials. Secondly, because it is time bound, our responsibility is to follow that due process. I think as Rob just explained, you don't want to have to change the timelines, but in certain situations, I would not make it a regular practice of business, but there are situations that necessitate that there might be a mutual agreement by the parent and the district that some things would happen differently. And like I said, but the whole purpose is that so that procedurally, if they're waiving rights, that we have done what we're supposed to do. The one thing that you have to understand about the district is we have a responsibility to do what we're supposed to do.
All right, thank you very much, Vice President Levy. Looks like Board Member Anderson, followed by Board Member Jacobs. And then I think we should probably move on from there. Go ahead.
So Rob, you already kind of hinted towards it, but my question is, so we're talking about the student receiving notice, but so when does the notice to the board happen? Is it the same day that the student gets the notice too? So that we can start kind of figuring out when we would have to be available.
This is a logistical question. I'll venture a statement, and it's going to be up to the administration, but I'm thinking that as soon as there's an idea that something is going to be moved toward expulsion, the board would be pulled for dates, even maybe before the notice went out. Of course, you got to have a date in the notice too, right? So the board's going to know as soon as there's an administrative recommendation for expulsion, the board's going to know because they're going to need to, not the substance, but you're going to need to know for scheduling purposes.
There might be a procedure in place for.
Oh, and there's.
Maybe I should come sit by you guys. What happens currently is at the pre-expulsion hearing, at the administrative hearing, the administrative hearing officer speaks with the parents about times and dates that work for them and immediately contacts what was the independent hearing officer, and it's right away that day.
And so moving forward, what will change is when we know that it's going to be a recommendation to the board, we will still collect that information from the family and work on a new process to notify the board secretary to get information out to the board and say, we have a notice of expulsion. These are in conversation with the student and the family. Here's some considerations. Please get information back to the board secretary by a certain amount of time. And it honestly will be to start with the availability, and then look for a nexus between what would work with the board, what potentially would work with the family. But then ultimately, as we were talking about, this is a statutory-driven timeline with statutory-driven language around the amount of time for notice as well as the amount of time to hold the hearing. And so ideally, we want to be within those timelines, but if circumstances arise, then we may have to move to that alternative.
Thank you very much. Great question. Board Member Jacobs, followed by Vice President Levy.
I'm going to hold off for now. Sorry, President Miller.
No, you're perfectly fine. Sounds great. If you change your mind, just
Can you
speak
hear
up.
me? My mic keeps going on and off. No, thank you. I'm going to just hold so we can continue on because I think things will come out in the mix. And thank you for letting me speak before.
Oh, yeah, no, of course, yeah. And if, I was just saying, if you change your mind, just drop a thing and we'll let you go. All right, Vice President Levy?
One, have we made this is discussion, but have we made a decision on who is sending the notice? And then secondly, if the process is that there's a pre-expulsion hearing with the administrative hearing officer, after that decision has been made that this is going to go to an expulsion, then, that intermediate step of talking with the parents about days where it would work for them, that's a part, but there's also the legal threshold of the timeline that we have to meet. And then in the end, once the board is polled, the day that we have a quorum, that through the polling, as long as it's within the legal time frame, that's probably going to be the day that the hearing has to be, when we have the quorum, so we can conduct the business that we're required to conduct. But are we going to make the decision on who's going to send the notice or not, or how are we handling that?
Great question. What was your, is that Dr. Kieser, did you want to take that, or does your team have a recommendation?
In talking with Ms. Beavers and myself, because we have that pre-expulsion process as an intervention step, at that time, that makes the most sense in working with the pre-expulsion officer and then the board secretary, because the board secretary will be the liaison with the board members. So it's going to be that communication, and then between those two individuals, we will get that notice out. And I agree that we will be using certified mail moving forward, so that way we will have a receipt of notification. Even though we currently ask for updated information, that will be a check on the check on the check to make sure that people are duly noticed.
That sounds great. Thanks, Vice President Levy. Did you have another thought?
Right. I'm just trying to understand. So the administration is going to handle the notice part. That's what we just decided.
That is my recommendation, and we can do it by acclamation, or if we need to do a vote. I've noticed the meeting so that we could take voting action tonight.
Okay. So, and then also the certified mail, which I'm in favor of, that also will appear in the expulsion packet as a example of evidence to show that we have followed due procedure, correct?
Currently in our packets, we do have a notice of the pre-expulsion officer legally signing off that the information has gone out. That I see continuing, but we will also have the certified mail receipt as an additional piece of information.
Right, because if it ever went to appeal, that notice, that evidence of that notice is already in the packet, which goes to the state superintendent.
I currently believe that the process that we have with the notice from the pre-expulsion officer meets that threshold, but this would be an additional measure.
Thank you so much for that. I'm going to recommend that we get through the whole, this whole explanation before we take formal action, just in case other things come up. So, but that's all really good stuff, and I've got a note to come back to that point, whether we need to go by acclamation or take a formal motion. So thank you for that. Thank you so much. If you'd like to continue.
Sure, and like I mentioned before too, Alana has some great examples from decisions from DPI looking at appeals regarding notice. So the next section then we're looking at is the expulsion hearing.
Could I make one final comment about the notice? I really think that what the board will want to end up with is making sure that the things that you currently cover in your notice, plus, if I can be a little humbly, some format that we would suggest could be really beneficial, just to give it a little bit of extra clarity. And that kind of draft, the board can ultimately review, but that's where I see the notice going, making sure that it has every component and in the most readable, understandable fashion.
So with the expulsion hearing section, again, it's one of those that statutorily, right, we're harping on the process. We want to make sure we follow due process in that we allow conversations from both sides. This is where, of course, you guys will discuss how involved you would like your legal counsel to be. There's a lot of times questions of evidence and hearsay, those legal terminologies that pop up that we have a wealth of knowledge on that we can always chime in within the hearing, have those discussions, especially if there's an attorney for the student involved as well. But there are different options written out. For example, the first one, the hearing is closed. Oftentimes it's because these students are minors. But the statute also does speak to that if they are not and either the parent or adult's pupil requests it, it can definitely still be closed. As I mentioned, right, you have the parents or the student has the opportunity of being represented as well. Oftentimes there are questions, and I'm sure pupil services handles those meetings and answers that we're part of the system, right, where we think, okay, if we're wrong, we got to be represented. It's oftentimes, I used to be a municipal prosecutor, it was always a hang up on, well, where's my lawyer? I need a lawyer. This is one of those situations where you're just, it's not a criminal violation, so you're not given or appointed a lawyer. But there are oftentimes many resources that, depending on the student's background, they may have. We've had in the past public defenders, just private counsel, or if the family knows somebody coming and representing them who happens to be a lawyer, there's an amalgamation. Another important part is the written minutes, because this is important for DPI's record, right? It's about what happened that day. It's not like we have the usual cliche civil litigation conversation of, well, let me depose Dr. Kieser, let me depose President Miller. It doesn't go that way. It's by, here's the school records, here's what we're providing. And there's a variation of how you can keep those records, right? There's the possibility of recording it and then transcribing it. I think Rob's had some experiences with court reporters, having, if that's a service you guys want to take through your legal counsel, that is always an option as well. And we try to make sure, again, speaking to our role and what you want our role to be, it's always a checklist that we have going on at the back of our mind during these hearings to make sure that you have the key components recorded down. So we'll go over those with you. We'll chime in, if we feel like there's a discussion that hasn't been made that's required, we'll chime in and say, oh, board, consider X, Y, and Z. So that, boom, it's part of the record. Then you have just a little outline of the procedure. Of course, this is always, we can always navigate this however the flow of the hearing is going, right? Whether it's the board that, or the president of the board that wants to say, okay, let me just do some housekeeping, let me explain the process, answer any questions, and then jump into the back and forth between administration and the student. If you want legal counsel to do that, we can always navigate that as well, and that is what one of the attachments are. There's a script of how the hearing can be handled. Of course, totally flexible, however you guys wish to run that. And maybe you'll see, you follow the script in the beginning, and it feels too rigid, or it's not flexible enough for having conversations and you want the kid to be heard. We can always navigate through that, create our own method that you would like to handle in the future. The usual part, as I mentioned before, is the back and forth, right? You want to have administration first puts on the case, so we know what's going on, right? You get the idea of the alleged conduct, the details from any witnesses, any information, or I'll use the term evidence, that administration brings up, and then You obviously get to answer or ask questions as well, because maybe you're confused about a fact pattern or want some more information. And then you can let the students go. They can ask questions. Eventually, they'll get their platform to explain everything that happened, provide their evidence. So it's very back and forth, but you definitely get to chime in on it. I think there was a question.
Oh, thank you so much. Yeah, I was just going to say we have a question. Go ahead, Board Member Jacobs.
Thank you. I just was thinking, if some of the members are virtual and some are in person with the parents, how is this going to be recorded and confidential?
And
I'm not a tech girl, so I'm just, can that be done?
yeah, there's a variety of, right, technology is on our side these days. There's
Okay.
a variety of options if you have, still just, if you're using Google Meets or Zoom or whatever have you, hopefully not Zoom, but you can have some recording device that'll still pick up on everything, right? Because if you're there virtually, there's still the speaker that plays out. If you don't choose that option, there's still the transcribing, right? So if there's a court reporter there, they're hearing everything and all the words are being typed out. Did you have another recommendation, Rob?
No.
Okay, no, that was it. Thank you.
Thank you very much, both of you. Board Member Delgado?
So in the past, the expulsion documents and all that used to get to us that was like our last step, right? Are we eliminating that step now because we're going to be involved in the actual hearing and we'll be actually hearing and looking at all the evidence and everything like firsthand?
Sure, your position has now changed from when you had the independent hearing officer being what we would call the trier of fact, right? They're pulling all the information and then making a decision, and then you're looking at it for confirmation with your authority. But in this situation, you guys are going to be the ones up there as the impartial group of people making the decision.
And I think this is a time to chime in on the evidence that you're going to get evidence to look at. Now you get a packet, right? And but this is a key in timing too, and this is part of this discussion. This topic is that we're recommending that you would get it at the same time the parents would at the beginning of the hearing. And I know that's counter to the board's general perspective, and I know we would love to be able to say everybody has a lot of time to get a feel for the evidence, but we're balancing your right to hear these and do it well versus due process. And so we want to make sure that you and the parents get the information at the same time. And how I envision that is at the beginning of the hearing, there might be a little bit of preliminary procedural discussion. And we envision that Pupil Services would also be available to make sure the parents get the information and get any questions answered. And the board would have an opportunity to have that information at the same time. And it would be right at the beginning of the hearing. And then the obligation of administration then would be to walk through the evidence. And then you will be exposed to that evidence at the same time rather than having an opportunity well in advance to digest it. And that just makes sense from a due process point of view.
So then would the board have time to deliberate and come up with a decision?
That's, we're going to get to that part of the procedure. Yes, it's a very important part of the procedure because, and that's a great question. You hear it and it's all new to you, so you're digesting it, and then you have an opportunity because you have the information with you. At the end, after all the questions are answered and all the evidence presented, you have an opportunity as the board to sit in closed session alone with the board only or with your representative and to go through it then and make sure that we've got some guideline questions for you to consider as part of deliberations. And that, just a quick overview would be, okay, what is the evidence? Was it proven? Does it require that we expel? What are our options? Is the child special ed? Those types of things. And those questions all will be asked, and you'll have an opportunity to deliberate and take the time you need.
Okay, so in the past, we were able to pretty much set a time when we look at those packets. Now we're going to be in actual hearings. There's going to be time sets. So taking that we are all employed somewhere else, how are we going to be able to manage, the times of scheduling those fair hearings? Like, for instance, myself, I won't be able to do anything until after 5. Otherwise, I'm going to have to take a day off.
So that really becomes part of that notice piece, Board Member Delgado. And so when we have the pre-expulsion and the recommendation is that it's not going to go to an alternative placement or back to school, it's going to be forwarded to an expulsion. Right at that moment is when we activate a process yet to be settled on, where the board is going to be pulled and say, we have an expulsion that's coming before the board. This is the time frame, this is the timeline, who's available when, and then whatever time frame we can get a quorum or better is who and when that is going to happen. So
I am very concerned about that because that's going to be a disservice to our families and to that child as well. We have a diverse board right now, and if we only meet in quorum and not have that whole diversity to look at, have different perspectives on that hearing, it's just very concerning, that we might potentially do a disservice to our families out there. But that's just my opinion.
All right, thank you. Board Member Wong?
You actually stole some of my questions as well, but is there a timeline that we have from the time that we're in the hearing and we get the information that we have to make a decision? Before we'd get it, they'd have the hearing, it was probably, I think, 30 days or something like that we had. Is there a timeline that we have to make a decision on?
Normally, it would be done the same day, because the closer you're hearing the evidence, the better decision you're going to make. I mean, if it was a really long hearing and everybody was not in a position to be able to decide, you might be able to extend, you might be able to notice another meeting and then come back the following day and finish it. But I don't know, have you had any of those experiences?
The only thing I was going to add is that just keeping in mind there's a max suspension timeline. So a lot of times, just because of everyone's availability, which we've been talking about, we're pretty close to that 15 days max of suspension by the time the hearing is held. So it's possible. I've had one time where a board, like Rob was saying, was deliberating so long into the night, and they're just like, you know what, we want to come at this with fresh eyes. And so they adjourned and then reconvened, and they had time to do so. But I think you just want to be mindful of, do we want the student coming back to school in 2 days if we haven't made a decision because the student's not expelled and the suspension timeline runs? I mean, unless you mutually agree otherwise, the student would then have the right to come back to school. So yeah, in my experience, like Rob's, it's normally right after the hearing, there's deliberations and then a decision. And I see a wide range. Some I'm in and out in an hour, some I'm there for 3 hours, some 4. I mean, it really is a pretty wide range of depending on what, the hearing is about and everything.
Thank you. I would echo the comments about the timeline. This is the concern I've had from day one of hearing this because I wasn't at the initial meeting. And knowing that we've been in suspension or expulsion hearings, which there's been 6 or 8 individuals, and the amount of time and the commitment that we have. The other thing that we have to consider here is that while I know it's a quorum, there could be people that automatically could be removed from that just because of their schedules that they have. And therefore, you're going to have potentially an impartial quorum making a decision on that. And I think this is a very valid concern that you bring up, Board Member Delgado, that it's not just the disservice, but it's also the process that we're going through. And are we going to be consistent or be able to be consistent? Thank you.
Thank you very much. Vice President Levy?
In regards to the time of the hearing, the regular business of this board is conducted at 7 p.m. on Tuesdays. And if what it takes to achieve a quorum of this board is that meetings start at 6 o'clock, and that is what we give to our administration, then there will be no meeting set before 6 o'clock. My understanding is that would be possible. The evidence that will be heard, I believe, in my practice, as an administrator, I've only presented evidence to our board at the expulsion hearing so that they are not, they don't know anything about it. And then there's a script that will follow in terms of what is the actual procedure when we're conducting the hearing. And then in terms of deliberation, I'm used to decisions being made that night. And as a board member, I would expect us to deliberate and make a decision that night, because we've had our administrative team present the evidence that should be clear and convincing that the student should be going for an expulsion hearing. And it comes back to anything. We're all elected. It's a quorum. People will be there or they won't be there. And there's nothing that anybody can do about that.
All right, thank you very much, Vice President Levy. Board Member Jacobs.
Thank you, President Miller. And this is why I voted nay at the meeting when we were deciding to do this, exactly for the reasons that Board Member Delgado said and Board Member Wong said. I really feel that we're doing a huge disservice to our families by the board taking over this role, and I'm very worried about impartiality, who will be available, and this is, as I said before, this is a city, and I'm doing air quotes, but it's really more like a small town, and people know people, and again, I'm very, very concerned about us doing right by our kids. Thank you.
Sure thing. I'm just going to interject quick because as I'm looking at the slide, this is on the expulsion hearing, and I appreciate that things are uncomfortable when we make changes. I think we need to kind of stay on topic on the actual proceedings of the hearing. I think we've had a lot of very good logistic issues raised that I'm sure that we're going to get through here this evening. So I just wanted to throw that out there. And then in terms of, could you actually speak to the impartiality piece? Because it's my understanding that you would just recuse.
Right, so, and that's a part of the next section, but no worries. Yeah, it's a conversation that we can have with the board. We'll always check for conflicts. Again, there's kind of point by point in which we go through and do you know this person? And it could be, we've had bizarre situations, right? Like maybe one of the board members have recused themselves and they were like an uncle or something, but also an attorney and wanting to represent the kid. There's so many bizarre variations that could happen, but we're there for those types of questions. We're there if you have concerns, we'll go over and address all the issues that can arise in, even if it's a neighbor, right? Or any circumstance that you could think of. And it just as what was mentioned earlier, right, is it's a small town. We know these kids. We'll go through that process with you guys.
Just simply knowing somebody, though, doesn't provide a bias, because you're going to know a lot of kids. So the bias would be if you were related or had, there would have to be a very, very direct situation. And we would ask you, and you're professionals, and this is what you do, you're the board, we would ask you, can you hear the evidence and rule well? Basically, we will ask you point blank if you feel you're biased, and if you say no, we're not, that's a trust issue. You know what I mean? And there's also the reason we do that in the script that Vice President Levy mentioned. We have the script right in there, and we have the guidelines right in there. And it might sound like there's a lack of trust, but it's really to protect the board. What we're trying to do is say, okay, we have all these things in place. The board can hear this case, and you're going to be able to make a good decision. And there might be a couple times where you say, I'm sorry, I'm related to that person, and then, yeah, everybody would say, well, that's, and you're going to recuse yourself from that. So
And then just one thing to add to that, I think what Rob said, I just wanted to highlight about being able to make a decision, based on the evidence presented at the hearing. I've just seen a couple situations, not here, in other districts where, where you do know the family, sometimes it's hard not to then chime in deliberation saying, oh, I know there's a lot going on with this family, I know, and share information that wasn't shared at the hearing and that the family didn't have a chance to respond to. So that's just something to keep in the back of your mind, like, during deliberations when everyone else is out of the room, to really stick to what was presented at the hearing, what's in this packet, and not based on any insider, knowledge you might have.
Great, thank you so much, and great question there. Board Member Jacobs, did you have anything else before I go on to Board Member Levy? Or are you good? Okay, sorry.
Oh, no, I'm good, thank you.
All right, sounds great. Vice President Levy then?
I know we're moving forward, but these questions about impartiality, is that being meant to impugn or suggest that someone may do something that is not right?
So I'm just going to jump in on that and just say that I'm going to defer that all of us are in line with our board norms and board agreements, and we're asking about it logistically and not without poor faith in each other, because one of our board norms is to assume the best. So that's going to be my response to that, and I hope that all of us as we move forward can keep that in mind.
And I was going to say that what we're suggesting, just the best practice, it's just questions to make sure the record's clear. There's absolutely no issue or agenda there at all. It's just what we recommend from a best practices point of view.
Thank you, and go ahead, Vice President Levy.
Now, I understand best practices in school discipline, and I'm willing to move forward, but I am explicitly asking about aspersions being cast. Now, I will follow the board norm and assume that that's not what took place, and I'm ready to move forward.
Sounds good. Thank you very much. So I think where we left off, we are on point A, overview of the hearing, and I think we did wrap up. I'm looking at my notes with written minutes of the meeting are kept. Does anybody have anything else before we move on there?
One question: the hearing is going to be closed? That's a determination that we're in agreement with.
I believe so.
Just one thing to note, because I know we're going to take action after we finish this section, but to Board Member Delgado's point, I think it would be really good if we had a time to which hearings could not start until after this time, to be understanding of everyone's schedule.
Noted, and thank you both for that. All right, go ahead, please.
So we were just going through the procedures and the back and forth that happens, the opportunities, the platforms, and then just like we see court on TV, right? Everyone gets to have their kind of outro, which is what we call closing statements. So basically, administration gets to wrap it up, finalize what their stance is, why it is that way. Then the student and their family gets to present and close up, basically. And then we jump into when the school board, so it's completely removed, right? We're not talking in front of any of the parties. We definitely, if you want your counsel to be there, like I mentioned, however you guys want to navigate our services and use us, we're there for you guys. And one of the attachments we'll get into in the next section, we'll go over some guidelines that we've dealt with in the past and that we would recommend, like when we were talking about, when Alana mentioned about, sticking to the facts that we heard, right? Not what we know outside of what happened in the hearing. These are all pointers that we make, and we'll go through those with you just shortly. The main component then in Section B, those are the things that if there is an issue on appeal, those two things is what DPI is going to look at. And I know I keep referring to appeal, making it seem like there's always going to be something wrong. It's just a matter of, here are the standards, here's what you want to make sure you're doing right. Of course, there's a purpose, right? You're looking out for the safety of students and the district. And then you're having to consider those as well before you make that decision to go through with the expulsion. And again, however you want us to navigate with you guys, we'll be there to make sure that those are on the record, right? There's oftentimes, and Alana will cover some of these experiences, that just because you have a standard, right, in law, or that the statute asks something of you, you can't just willy-nilly later on put it in the order. You have to make sure there are discussions about it. And so we'll make sure we'll ask those questions, board, do you want to consider this, or do you want to have a conversation on these matters? We want to make sure you get those on the record and not after the fact just writing it up in the order, and we'll go over that as well.
That's perfect. Thank you so much. Vice President Levy had a question. Go ahead, please.
No, we can move
We're
forward.
good? Okay, sorry about that. All right, and thank you so much.
So the next section is about the guidelines that we have for school board discussion and deliberations. And so I know we kind of incorporated this when we were talking about the hearing. This is where we use the term impartial, right? Because in any situation where you're looking at due process, you don't want there to be someone who is biased, someone who knows more and uses things that aren't noticed to the person who's alleged. You want to make sure it's crisp and clean. And so the attachments regarding this section will walk you through questions, examples, the position you want to take, how your mindset should be when you're walking into this hearing, when you're digesting the facts that are coming to you. And like I said, we're always there. If you have any questions on, what's going on with this fact, was this even relevant, or any of that nature, we're there for you during deliberations to cover those grounds. Basic things like, please don't make any comments which would indicate you have already made a decision in the stance. And that goes to one of the questions of why you don't get the packet in advance, right? Even though you're one of the justifications could be, well, if I have a view on this situation and conduct, I'm going to still have that view of the situation and conduct if I got notice of it later. But there's always other circumstances that you're not aware of, right? Whether it's talking in the past with someone or just research that you happen to do. I mean, it's not exactly the same, but I try to equivocate it to jury duty, right? How many times do you hear the judge say, don't go researching, don't go looking on the news, because they're getting extra information from the parties before the trial starts. And so just, key pointers there. Obviously don't consider the race, sex, sexual orientation, national origin, all those fine protections that we have. Again, one of the important parts, and this goes to, we always harp on procedure, right? We want to make sure we don't muddy the waters with due process. And so you don't want to have these comments and the things that should be left for deliberation on the floor with the parties there, right? It's a crazy nuance that will definitely not be good, because you have a session for that very specific reason, is to go through your guidelines of what should be considered during deliberations and not make those comments in front of the parties. Other parts of the packet will show you, it's kind of repetitive. So some of the things in the outline, right, are taken directly from what we recommend. But there's also, sorry, I'm so sorry.
No, you're fine. Actually, there's a couple of questions in the queue. And actually, can I cut in line real quick? Because I did have a quick clarification. You said that one of the guidelines is so exercise caution when asking questions. So let's say I ask a question and I, in good faith, think that it's appropriate, but it's not appropriate. Would that be a role, for example, you had alluded earlier to determining the role of counsel? How would that be handled, both with you or without you? You could just kind of walk us through that, somebody asked an inappropriate question.
I can start, and then Sheila or Rob, you can chime in. But I can give a couple of examples. One, there was an expulsion appeal decision a few years ago where the board, remember how Sheila was talking about repeated refusal and how we want to make sure any instances or incidents that we're relying on for the expulsion are in the notice. There was one where, and how you get the packet, and a lot of times there's background information about the student, like attendance, their disciplinary record. So I can think of one expulsion appeal where the board, rightly so, was looking at the background information, wanted to consider the whole picture of the student, and ask some questions about some of the background disciplinary incidents, but really, really keyed in on one disciplinary incident that wasn't in the notice. And then at the end, the administration clarified, yes, that happened. That wasn't one of the bases for our recommendation. The state superintendent said that the discussion went so in depth and based on some of the board members' questions, comments, found a procedural violation because even though it wasn't listed in the order, there was so much robust discussion and questioning, and the board was very bothered by that incident, but it wasn't in the notice. The other thing that comes to mind, I'll talk about this in the special education section too, but one thing, and we would, of course, if we're there, not say it in an embarrassing or corrective way, but I sometimes remind the board, that the incident we're discussing is not, listed in the notice. Of course, it can be considered as background information just to kind of cue you guys to maybe let's leave that line of questioning, you know what I mean, without saying you're out of order or that's inappropriate. But some questions have come up about disability status or what's in the IEP, and that's something we normally caution against for reasons I can explain when we get to the special ed portion.
Perfect, Dan. And I don't want to, we can wait until we get there. I appreciate just the general information on that. So I'm going to go to Board Member Levy, followed by Vice President Levy.
Just a logistical question. Who is present at the hearing when? So of course, everyone's present for the formal hearing, but during deliberation, is the family and administration excused and it's just the board and the attorney or?
Exactly it.
Okay.
So you kind of want to look at it like when you go into closed session, right, for voting or litigation matters, all those examples that we have for public records and open meetings, right? In this situation, it's very similar. You're going into a closed session. If you want the attorneys there, we'll be there for you. And that is just you guys handling what you're talking about and going through the analysis of, okay, what was the conduct? Does it meet this? How does it affect the school district? And all.
Are parties that were involved in the first part of the hearing able to stay and wait in a second session to get the kind of the conclusion, or is they go home, someone will call you in the morning?
Right, so that could vary, just like the last example, right? Okay, well, what if we gotta turn around and do this tomorrow? They're not gonna be spending the night in the room, but Alana can speak to the process.
Yeah, I was just going to tell a story. I think the normal practice lately has been, one, because we don't know how long deliberations will take, but I'd say the norm is the family goes home, someone, usually from the administration, calls with a decision. Some districts give the option of waiting. The only caution I was going to give is, one of our colleagues one time got a chair thrown at him after they expelled a student because the family was very angry. So that's some reasons why some boards decide to say, well, we won't call everybody back in to give the bad news, but that's certainly an option, if you want to give families the option to wait.
And you definitely will have the order part. We'll go over that through the next section. And then, like we said, flexibility is always an option. We're just going to make sure that we're there to chime in on procedure, legal standings, and whatnot.
Thank you.
Perfect, thank you so much. Vice President Levy?
What is the administration's current practice about the discipline record that's presented? Is it the student does something in April of their 11th grade year? Is every behavior incident from Skyward being printed in that packet when that packet comes to the board for the hearing?
Yeah, to my understanding is yes. So if there's an expulsion hearing that particularly talks about repeated refusal, it's going to list all of that, and to the degree that it's a singular specific incident, it's always put in there. I'm getting the message from Ms. Beavers.
Right. So then my second question is, when the administration makes this presentation to the administrative hearing officer, let's say the student had a fight and the severity of injury was great to some other kid. That's why it's not just a regular school fight, but something that's being brought to an expulsion hearing because somebody was grievously injured. When our administration or that administrative hearing officer is looking at that in their presentation, do you talk about, this is the incident that brings us to this hearing today? Joe had a fight with Bob. Bob has been hospitalized. And before this fight, here are representative other behaviors that Bob has had. I mean, like, how has that gone in your practice of presenting these?
I can't speak to the process here. I can only speak to my own personal experience, which would be in a different district. Apologize.
All right. Oh, that's all right. So I do want someone from here to answer that for me.
I do not sit in administrative hearings, so I cannot answer that either.
Expulsion hearings.
I do not sit in expulsion hearings either, so I have not.
Well, right, okay. So then that would be one of the things that do our principals sit in those hearings?
Yes.
Okay. Because that's part of the reason that I made the decision to take this process on as a board member, because there are some spaces where we don't know what all the practice is.
To my knowledge from the discussion, Vice President Levy, is that while it is a part of the packet, the discussion from the board is going to be zeroing in, if it's noticed as a singular incident, should be focused in on that incident, and the rest is background information for context. It would really have to be focused in on what was noticed for the reason for the hearing. And so whether
right, but
yep, sorry.
Right, but yeah, I'm going to say, that's my point about as things are being presented, because part of us scripting out this process, the administration will make up how they're going to present, but it's about understanding what's being presented, because that's the place where these other questions kind of come about. There might be one incident that's expellable, but let's just say the kid's late every day, and that creates a behavior record. So he's got 98 behavior records, and they're all just truancies, but they're there. And people are looking at 98 behavior incidents like, oh my God, what has this kid done, without that context or understanding. And sometimes they're more than just truancies. They are other things of other severity that might be disturbing to a board member, but those things had not been expellable offenses or brought at that point.
Right, and if I could chime in too, that is one of the considerations that you guys as board members want to focus on. And of course, if you have us there, we'll bring that up, in that there are different variations of, we'll call it information gathering, right? One, what you're reading within the packet in the different, like you said, behavioral reports or other documentation that's within that packet that's accessible to you then. Then there's also information you're gathering from the hearing that's taking place. And that is the key of your deliberations, is the evidence presented during the hearing. One of the situations, and I think Alana might speak to it, in the examples of DPI's decisions is, like we were talking about earlier, right? We can't willy-nilly put stuff in the order after the fact because you read something. It had to have been presented, and for things to had been presented had to be noticed. So there's kind of like a roadmap before you get to the point of taking into consideration other things. And usually that should only happen when there is the notice of repeated refusals, and those incidents are noticed in detail within the notice. That's a lot of notices, sorry. And then you move forward. So then you get to the hearing, right? Did administration even bring on all of those? Sure, it was noticed, but did they present that evidence to you? What information was provided that you're hearing, that you're seeing in that moment, and then jumping into deliberation. So there's kind of, like I said, we'll be there to bring those things up, but there is kind of like a barrier in where you're using just what you're hearing as evidence, if that clears anything up.
And the notice says, like, each parent's notice that, sorry.
The sample notice, our expulsion notice, gives the family notice, again, a lot of notices, that their entire record can be, entered in as part of the evidence and considered by the board. And then I think, it's just, the administration and board's responsibility to kind of, consider the background information. I think DPI says it's okay to consider those things more, not like whether to expel the student, but whether, the terms and conditions of expulsion, like how long should it be? Should we allow an opportunity to come back early, which I'll talk about, just like we'd consider, information the family shared about what's going on at home or mental health concerns, or, it's kind of the whole picture that the board is able to consider when it's talking about the length and conditions of expulsion.
Thank you so much. Vice President Levy, are you good?
I'm good.
All right, thank you so much. Board Member Jacobs?
Thank you. If one of the attorneys could correct me, or if I am wrong, but back in the day, not all administrative hearings went to an expulsion hearing when I was principal. And if they're not done correctly, they're kicked back to the school. Well, I want to say kicked back to the school, but they're dismissed and they're not forwarded on to an expulsion if something procedurally wasn't done correctly or if the principal didn't do something correctly, right?
Right. Sorry.
Sorry,
Go ahead.
that is correct. So really when we think about it in terms of kind of contextualizing it to a school situation, we're talking about kind of classroom managed, so that would be the things that we handle administratively, and office managed, and that's what we're talking about here. So administratively, we handle everything up to and including the pre-expulsion. And so along that whole process, if we do something against our own policies, we have a duty and a responsibility to deal with it at that point. What we're actually doing at this point is saying it's gotten all the way through that, and now we're actually in kind of the school term, we're writing the referral and we're sending it to the principal's office. You are in term the principal, and you only hear one type of a referral, and that's an expulsion. And so what we're talking about is all of the technicalities and procedures by which have to be followed in order for that process to carry out, if that helps.
Yeah, it does. And I'm looking forward to seeing, I know a year ago, the board had directed you and your team and Ms. Beavers to really work on training all the principals, which you've done, so that everyone's on the same page on what to do in regard to administrative hearings. And we, because of COVID, haven't had a chance to see that, but I'm sure that what we're going to see this year is going to be marvelous. Thanks.
Thank you so much, Board Member Jacobs. Board Member Levy?
Just a clarifying question. So not talking about repeated refusal to obey the rules, but since the board has kind of a constraint, for lack of a better term, of just stick to what was presented, don't introduce any outside information, why would the administration present additional information outside of the reason why the student is being brought to expulsion? And again, omitting repeated refusal, because that one would be a separate category.
Sure. I'll vaguely say context matters in a lot of these, right? So depending on what administration is trying to convey and connect there, I'm not clairvoyant, but there could be something I'm not thinking of, maybe Alana is, where there should be the consideration of this behavior, whether it is like constantly that there's numbers related to something that led up to this event, right? Even though it's not about those repeated refusals, it speaks to the nature of that significant conduct that happened. So it's not that any outside information is completely nullified. There should be a nexus that you would consider when you're making that final analysis of, okay, what harm did this conduct do, right? Because that's the number one thing. And then how is the school district affected by it? And Alana can add to that.
Yeah, and these are good questions because this is one of the, I think, harder distinctions that we try and navigate. Is it's like I said before, what's in the notice is the basis for the expulsion itself, like yes or no, should we expel the student? But then when you're thinking about, should it be the max, like age 21, or just for a semester, or like, what are the conditions going to be? I think that's where the board would appreciate an opportunity to kind of see the full picture of the student, and also, consider information presented from the family. And so if the family paints a picture like my child has never gotten in trouble before, they're an angel, we can look at their disciplinary record and say like, oh, that's true, hopefully, or oh, that's not. And it doesn't mean, you'd go into depth on each incident in the past, 12 years, but typically I think the best practice would be for the administration to kind of characterize. So like on page 8 of the expulsion packet, you'll see disciplinary records, you'll see that they're mostly tardies, or, kind of characterize, you'll see 5 incidents of physical aggression, but it gives you an opportunity to kind of say, because you might not know the student, and this is a really, hard decision for you guys that you make after meeting the family just for a little bit. So I think it's a nice way to be able to kind of consider the whole picture. It's just the balance is, don't go too far down a rabbit hole in the background information. And I know that's, it's not a black line. It's kind of different in every scenario, I guess. Like when it's just kind of a overall caution, but as board members, it's certainly appropriate for you to have background information so you can consider the whole picture.
So just for clarity, and I really want us to be consistent in our decision-making, the board cannot provide context from personal information because the board is not presenting the case. The administration and the family can provide context because they are contributing to the case that we are hearing. And then my second point of clarification is, does all information that is considered as background have to be verbally presented in the case? Because when you say stick to, like the records and what's being reviewed, and will parents be explicit, and I guess this is kind of what we need to determine, will parents be explicitly told, like, you have the ability to provide context, but it has to be on the record in order for the board to consider it?
Yeah, so when we say on the record, that can be verbal or in the packet. So a lot of times, like the administration, like I said, won't go through every disciplinary incident or attendance, but that's something that you guys will review, take the time to review in the packet, and the administration might highlight certain things. Same with the family. They're not going to be able to get things into the packet, but I've had families, provide a letter of support from a coach or a letter from a mental health provider or any information. If I'm sitting with the board in an expulsion hearing, typically I would meet with the family before and along with the administration and kind of informally say, this is what it's going to look like, and really encourage them and the student, which I know it's intimidating for a student to be in front of the school board, but just really encourage them to share any information they want you guys to know. So that would all be then part of the record you could consider. And then my last comment is when you said, it's not the board's role to like introduce information. The board members can ask questions and should ask questions. So if there's information you're looking for from the administration, or you have a question about the context, then it's certainly appropriate for the board to ask, and then the answer's in the record, if that makes sense.
No, that's very helpful. Thank you.
And I'm also suggesting that, and this is one of the things that was a board concern, was making sure that parents weren't completely in the lurch. And so, I think that what the administration's thinking about is that pupil services would provide some liaison, to make sure this is what's going to happen. Any questions and answers on the notice, explaining what the procedures are going to be, and that makes sense so that parents are fully able to present information.
Right, and further clarify if your question was about looking at evidence in a tangible form, right? Is it just what's on paper, a letter that's presented? Testimony is always evidence. So if it's something that the student is saying and you want to take that for fact, that's on you. That's evidence that you can consider.
And I know that we could keep talking about this all night, but the one thing that I also want to say is if there's a large packet and not every document is referenced, the board can say we're accepting all that as evidence. And so that is on the record then, even if it's not all. And the parent is the same thing. You know, the parent can say, I took all these documents with, and the board can take that as evidence. And then you can determine the relevance or the importance or the value of it.
Thank you so much for all of that clarity. Thank you so much to Dr. Kieser's team for that piece too. Okay, going on then to, it looks like Vice President Levy.
You know, for some of that conversation about the evidence, like I said, procedurally, once we see the script, there's times where this is the information against the students that, evidence that's supporting the expulsion that the administration is seeking, whether that's paper, whether it's student interviews, whether it's DVDs of the recorded incident, all of that will be presented to us, or whatever pieces of evidence they choose to highlight if they've got the entire behavior record. And then usually after the presentation of the evidence against the student has the ability to make a statement or present things that they have. And then the board members, if we were going to ask questions, would ask questions there to understand. Sometimes simply I've seen board members ask students, why did you do this? And sometimes the kids will answer, sometimes they won't. That's one aspect. And then I think another part that was not mentioned, but although it was referenced earlier, is because this is a school board meeting, you would expect that there's an orderly process. But because you are, telling people or dealing in a situation that's very, it's an adverse situation for a student, that sometimes parents and students can become unruly in the process. As I think one of the attorneys mentioned about chairs being thrown at the end of a deliberation when things were given, it's also my expectation that, if people are behaving inappropriately, that's one thing, but also too that the demeanor and the constitution and composure of our administrative team as they're presenting the case that, will go through. So there, in some of these cases, there could be issues like that too, that to think about behavior.
Thank you so much. I just want to check in with everybody. Do we want to go for about another 10 minutes and take like a 5-minute recess? Or do we just want to push through? Anybody have a strong opinion? All right, well, I'm going to say, why don't you let me know when you want to get through the next kind of let us know a logical place to pause in case people need to stretch or take care of stuff, and then we can come back.
Let's get through the script, and before we go with the order, we can maybe take a break.
All right, thank you for that. Sounds good.
And so just the last part of the section was, and we briefly did discuss some of these concerns, is the last example in that attachment. So we're still looking at attachment number 3, is the script for board deliberation. So as we mentioned, right, we're there with you. We want to make sure all points are covered. We want to make sure the record is clear. We want to make sure you're looking at the information that's provided to you, that was provided to you during that hearing. We want to look at how we're moving forward with this. So if you all arrived at a conclusion, what do you want to do next? And those are details that Alana will get through on reinstatement conditions, because those are things you're going to talk about, right? These are the order that comes at the end of everything is. We'll go through that after the break. It will be spot on, and the reason why we want these questions answered is that so that there isn't anything hanging out when we give the parents and the student everything to look forward to after a decision is made. And that is the conclusion.
To wrap this section up, we provided guidelines. Those are general. And those kind of dealt with making, the atmosphere and also being able to hear the evidence appropriately. And then the script is very much like Vice President Levy said, from start to finish, exactly how the hearing is going to run, so that it's orderly. And it might not be perfect, or words might not be perfectly the way you would want them, but I think it gives you a context to get started with, to say, this is the type of process, and it lays out exactly what we've been talking about in the back and forth, and just, even as simple as saying, okay, Parents, we're going to give you the opportunity now to present, or student. And so any evidence you have, you'll be presenting now. And then thereafter, the administration or the board will ask questions, that type of thing. Exactly every step of the way so that it's all charted out. It's very structured. Obviously, there's freedom and communication in between, but it's got very structured. And then the deliberations ask the key questions that the board needs to work through to make a decision. And I'm guessing the board, you did have an opportunity to look at those, and it's probably, at least it's a starting point to work off of as the board works through this. And I think the cool thing is that, for example, if you have your first hearing and you work through the documents and everything, you think, oh, we should tweak it here, we should tweak it there. I mean, I think that could be very useful.
No, definitely. Thank you so much. Board Member Levy, you had a question?
So number 10, A and B are those kind of questions concerning recusal. I am assuming when the board is polled for availability that those recusal questions will be like, it's student X, here are the recusal questions, because we would hate to be in a position where we had 4 board members show up and then someone recuses at the last minute. So that will be handled with polling for availability. Is that the standard practice?
Availability, and then again, we're into building a record, as you can tell, but we probably build the record again then at the hearing. But that's a really good thing, because it may be, if somebody's related, then they're not going to be part of the quorum, and it's good to know that at that time. So that's probably a good practice to say, here's the recusal questions to make sure you're aware. Yeah, good.
Thank you so much for that, Board Member Levy, and thank you so much. Vice President Levy?
In response to Board Member Levy's question, it was not my thought that we would know. Let's say an administrative hearing has been held and John Brown is going to be recommended for an expulsion. Because it's a student record, the only person that knows that is the administration and our independent hearing officer. The only thing that the Board of Education members know is that a expulsion hearing needs to be scheduled. If we all have information that it's John Brown prior to, then hey, I heard John Brown did something. In my practice, we've not given names of students before there was an expulsion hearing. I know you're saying that, well, when the students get there, that's when you find out what the student is and what the issue actually was. And if you were John Brown's godfather or uncle or brother or cousin, then maybe you'll make a different decision. Like you said, based on why you should be excluding yourself from that. But if you know the student's name before, I don't understand how that works. And if there were 4 people and that person needs to go out, then you don't have a quorum. And you got to do something else to maintain due process, or work with that family to say, whatever. But that would be one of those situations.
Thank you for that, Vice President Levy. Board Member Delgado?
I think Rob was going to say something.
My apologies.
You're probably going to know from the notice, if the board gets a copy of the notice, what the name of the student is. So I think it's a really great question you raised, and I think that that's something that we need to ponder, is whether that would be prejudicial or not. I'm going to look into that. I don't think it would be, but I think it's a great point.
Why does the board get copy of the notice? Would that be a decision that we make if we choose to include?
Yeah, if you choose not to, I'm just thinking about the date and the time and being aware of it. But you're right, you might get the notice at the time, so that's another decision. You might not. Maybe that would only go to the administration or the board president, or maybe no information, name or notice. That's another thing. Yeah.
Well, I know we're kind of going back and forth. My thought as we're proceeding is that board members would just be notified that there's a need to have an expulsion hearing. This is that, the polling would take place to make sure that a quorum could be seated. And so the only thing that we know is there's a need for an expulsion hearing, not who the student is or what the incident is before us.
So I'm just going to enter, because I feel like this is a discussion that we can have at the end when we take some kind of action. So I appreciate you bringing all this up. I do want to go back to Board Member Delgado.
Thank you. My question is, regardless of when a board member excludes themselves because of knowing the student or whatever, maybe, is the board member still allowed to hear the hearing but without any type of participation?
We would probably recommend against that, because then you would never be accused of any, if you had a bias and you were there, either body language or anything. I mean, I think it's to protect the board member and the board. Probably not.
Thank you.
Thank you for that question. Board Secretary Shope put a note in the chat and asked, what if it's only asked, and I believe about the point at hand about whether or not you need to recuse, when we only can get 4 people. So I think she's, and I don't want to put words in her mouth, but I think she's asking, like, if there are, like, let's say everybody could only meet Thursday at 6:30, we could only get 4 people, and one of those 4 people has to recuse.
Then we would have to make a decision at that point for the next step. So we would have to have a plan for that.
Okay, and maybe that's a consideration, maybe to push to the end when we have to take some kind of action and procedure going forward. Does that sound good? Okay. Thank you very much for that, Board Secretary Shope. Vice President Levy?
Yeah, some of these questions that we're talking, like I said, they're procedural because, the notice of hearing, what's going to be heard by a board member, and when we ask, I would think that the recusal question should be asked at each setting of the board for an expulsion hearing, not only if there's 4 people.
And that's what our script calls for, yes. Correct.
See, one of the things, like as we're talking about, some of the questions that we have about consistency, the script that we have after we actually, decide on what our role is in the process, that's what creates the consistency, that we perform our function as we decide it and write it out.
You are correct, Vice President Levy, and because the script that we had under the old process is very similar to the script that is presented. So this is I don't want to say a standardized script because it's not. It's the script that Rob and the team have developed, but it has all the procedural elements, including the requirement, which is statutory, that it has to be impartial. So every script will have a question to the board about excusing themselves.
Go ahead, Vice
Just
President.
another part too. We might, once we decide our script and done, we may need to role play it through also.
Absolutely.
Great suggestion. Thank you for that.
And that was it for that section. So if we want to take a break now before we get to the expulsion order details.
Great. It's 7:32. Let's recess for 5 minutes and meet back at 7:37. Thanks, folks.
I have not had to stand this long. Do you want to? I almost, Rob, I don't know if you saw my face, but when I tapped out, I'm so glad you went and got water because we were pretty sure I was blacked out.
All right, thank you very much, everybody. We are winding down our recess and reconvening. It is actually 7:39 at this time, and so, no, you are totally fine. And then take it away, team.
Is this on? Yeah, okay. So I am going to briefly go over the expulsion order, and this will tie into the next section where I talk about early reinstatement conditions, which could be part of a possible expulsion order. So the expulsion order, like Sheila was previewing, you go through at the hearing. The two main decision points are, one, did the student do what the student is accused of doing? And that should be tied to the expulsion notice. And then two, do the interests of the school demand the student's expulsion? So those are two things, and I'm kind of skipping to B, I'll go back to A. But those are two things that would be in the order. It would really, there's normally, and there's an attachment, a template for the order, but it would kind of give the background, like on this date, the board, conducted a hearing. We note whether the student was present and had the chance to provide information, go through the findings, conclusions, the term of expulsion, so how long it's going to be. Is it going to be to the max age 21 or something less than that? A statement prohibiting the student from being on school grounds during the term of expulsion. And then there's other things that might be in there but don't have to be. So one, I'll get to this in the special education section, but if the child is identified as having a disability under the IDEA or Section 504, we would normally put that in the order and say, I don't know if this will make sense now before I get to that part, but that a manifestation determination was conducted and it wasn't a manifestation. And then we would also put in any early reinstatement conditions, which there may or may not be. So we can get a good template going, and we attached a sample template, but it's going to be different, look different every time, because the findings are going to be different every time depending on what was alleged and what the board concludes. And it's not as if the findings have to go into great detail. It would a lot of times kind of mirror what's in the expulsion notice itself. So like on this date, student so-and-so, possessed alcohol on school grounds. Like it's not like we're going to be paragraph long findings. They're usually pretty brief and more summary in nature, and then tied to the statutory grounds for expulsion then. So if the board decides to expel, then there is an expulsion order that would get mailed to the student, and if the student's a minor, also to the student's parents. When a student has been expelled in C, you'll see that other school districts, public school districts in Wisconsin, have the option, but they are not required to enroll the student during that term of expulsion. So a lot of times boards will ask, and you can certainly ask this of the administration in advance or during a hearing, what options does the student have, whether it's services provided by Beloit or, the student would have the option of enrolling in a private school or doing something virtual. But public schools have the discretion, whether to accept an expelled student or not. And the last note I had before I can pause for board discussion on the order template, and then like I said, I'll talk about things that may or may not be in the order depending on the circumstances. If legal counsel is sitting with the board during deliberations, one thing I personally like to do is, give the board the option of, do you just want to start with a freewheeling discussion of, hey, what do we think about the hearing, and start, just debriefing about it, or would you like legal counsel to start with just some kind of guiding deliberation questions? And normally we kind of start with the easier things, not easy, but did the student engage in the conduct set forth in the notice, and then kind of work our way to, and as a result, should the student be expelled? If so, for how long? And we'll kind of take you through the main decision points and the stuff that would be in the order if the board does decide to expel.
And I just have one thing to say about the template. We gave an example of an order that you've used, and then we put together a template. And I see the big difference being that we try to have findings of fact and conclusions, and then the order. You can also, if you take a look at what's been used, all the right information is there, but it's a little bit more bullet pointed. And so The statute doesn't say you have to have findings of fact and conclusions of law, or conclusions, but it's nice to say the board went through these things and this is what the board found. And then these are the conclusions as a result of that the board reached. It's very helpful for an order. It's very clear for the parents. It's helpful if there is an appeal.
Yeah, and so did you want me to go ahead to the early reinstatement conditions, which might be in the order then? Okay, so on the next slide, you'll see this is, I feel like a lot of our time tonight has been spent talking about, here are statutory requirements, required timelines. This is a nice section because this is one area the board has a lot of discretion. And there's other areas too. I don't want to make it seem like there's only one way to do the expulsion process. You guys have discretion when it comes to how long expulsion should be, what weight to give certain evidence. The early reinstatement conditions, why boards, I think they're becoming, at least from my experience, a little more common to include. So let me just explain what they are first, and then I can kind of go through maybe some trends that I'm seeing or what other boards have discussed in deliberations. But so early reinstatement, that basically means that we're allowing the student to come back to school early. So let's say we expel to age 21, but then the board in deliberations decides, if the student does X, Y, and Z and kind of proves himself or herself, to us, we'll let the student come back early. So conditions can be one of two kinds or both. Either things the student has to do before the student's allowed to come back to school, and or things the student has to do after they're allowed to come back early. So some common examples, and note in the outline, they have to be related to the reasons for the student's expulsion. So common ones I've seen is, let's say if it's a AODA violation, sometimes a board would decide, well, we'll expel for 3 years, which would be until graduation. But if the student gets AODA assessments, counseling, we get verification that they've followed treatment provider recommendations, there's been no negative law enforcement contact, then the student can come back, at the beginning of next school year. And then once the student comes back for that remainder of the term of expulsion, so for the next, 3 years then, here's other conditions the student has to meet, like consenting to backpack searches or meetings with the guidance counselor, or like check-in, check-outs. There's a lot of discretion, and typically the administration would recommend, certain early reinstatement conditions, so the board isn't kind of creating them from scratch, but you do have a lot of discretion there. And then first, we talk about if they're met. The administration is the one that would determine if they're met, so it doesn't come back to the board necessarily for the board to take a look at, okay, let's go down the list. Did the student get the counseling? Was there any negative contact with law enforcement? And same with violations. So let's say we let the student come back to school early, and we have in there, you can't commit any suspendable offenses for the remainder of the term of expulsion, and the student commits a suspendable offense. It's typically the administration that then determines, will reinstate the order of the board, because as the board, you already ordered expulsion until, let's say, age 21, and then it's the administration who typically would then look at, are the conditions met, or do we need to kick that order of the board back into gear, if that makes sense. Are there any questions about early reinstatement conditions? I can talk about a few other things with those, but I know sometimes this is a confusing point because there's so many options.
We do have one question from Board Member Levy.
I think this question might be for Ms. Beavers, just for a historical perspective. Is there any internal data collection on expellable offenses and then the terms or conditions of the expulsion and early release? So I'll start there, because if yes, then I have additional questions.
So let me just be clear, I understand you. Are you asking if there's data that would represent the term, like the length of the expulsion?
Yeah, so 17 kids were expelled for this similar infraction, and then this was the outcome. These were the orders of the expulsion.
So we have the data on the number of students expelled and for what offenses. We don't track the length of time attached to the.
Perfect. So then, Rob, this part of the question would bounce back to your team. Is there anything keeping the district from collecting that type of data? Because I'm always interested in continuous improvement, and I want to make sure that we're being consistent. And Dr. Kieser, please correct me if I'm wrong. I believe that in a previous statement, you said that our district does have disparate outcomes by race with expulsions, placements, et cetera. So I would be interested, unless there's something that precludes us from keeping this, and it wouldn't be assigned to a student, so John Smith or whatever, but expellable offenses, the conditions of the expulsion, and then the race of the student, or I would want to have special ed identifications there, so we can so we can track, are we being equitable in our decision making, and if no, then we can take corrective action as a board.
Yeah. Oh.
We do have all of that data. We get an annual report, and everything you just listed is in that report, just not the length of expulsion.
Okay, is there any way that we can add on to the database that I'm glad to hear we already have, and it has the link? Because if we are unknowingly, as a collection of board members, putting different terms for different groups of students, then I want that to be flagged in some way so we can correct that.
Yeah, oh.
Go ahead.
I was going to say, from a legal perspective, that's fine. And different boards have also asked the administration. I was just at a expulsion hearing the other week where during deliberations, one of the board members asked, like, when setting the early reinstatement conditions, they're like, I wonder how many students actually successfully satisfy the criteria and come back, because that's something that the board might not always know. So they asked the administration to kind of gather some data and present it to the board. So that's certainly within the board's purview to take a look at that type of data.
I also think that this is an area that I've been thinking about for consistency, because I know that's a concern of the board. And that's a little bit of a precedent issue. And now that the board is going to take on this process, I think it's important for the board to say, when we had this situation last time, this is what happened. At least be aware of that. You know what I mean? And now no situation is exactly the same, but I think that's a useful tool for consistency, including in situations where maybe there's a different quorum or not all the board members can attend every time. I think that information is important to have.
That is exactly where I was heading with this. For consistency, if we can have a guideline of what our precedent has been in the district, and of course every situation is different, but I would like to have that guideline to start with.
Thank you very much for that, Board Member Levy. Vice President Levy?
Yeah, to some of the things that Board Member Levy just brought up, I understand the data tracking, but one of the things that I was in my thoughts about the expulsion outcomes themselves is each situation is different. The findings of fact, the evidence that's presented, they're all different and they're all individual students. So I understand on a certain level when people are saying, let's have a consistency. If this student had marijuana and this student had marijuana, but even like there's a student who brings marijuana with intent to deliver, and there's a student who's in possession of marijuana. And although they're both marijuana, those are different things. And so it's very detailed and specific. So in some ways, those overgeneralizations don't exactly get us to the space of providing the first time examination of the case and the evidence for the individual student, because it's a student welfare hearing for that individual student, not other kids in front of them or after, before them or after them. It's a student welfare hearing for that individual student. Now, our policies are the same, but one of the things that I was going to ask a question about earlier, like you said about weight of evidence, just before we get to our board expulsion, but the weight of evidence, you know, how Board Member Miller weighs one piece of evidence versus how I weigh a piece of evidence could be totally different. When we come to the place of our deliberation, where we're trying to, what weight am I going to give to that, and that made me decide this and that made her decide something else, that it demands expulsion. It could very well be different, that depending on what the quorum is, if it's all 7 board members, or if it's 4 board members, or what 4 board members, that If the board decides it's expellable, it'll be expellable. If the board decides it's not expellable, it won't be expellable. I mean, that's just kind of the reality of the decision-making process. And then also, too, I think what we're talking about is good because for terms of expulsions, our administration will go through a process, or we might give some guidance, or there'll be some understanding or some conversation about terms of expulsions. There are some places and some districts that expel to age 21, and there's other places that would not put their students out that long, depending on what it is. Will there be services or no services? Are we going to allow conditional reentry or not? Conditions that need to be met before or after. So that's a whole nother level of conversation. And some of those things might come out. What I would expect is that our board would make, that our administration, when presenting a case, would come with an administrative recommendation of the term of the expulsion and if there are going to be conditions or not. But also, too, as has been stated, that if the board does not go with the administration's decision, that is not micromanaging. That's the board exercising the authority that we have, and it could come to different cases for different reasons. So there's a lot of latitude, and has to be understood as that latitude is your authority to do the things that you've been granted the right to do.
Thank you very much, Vice President Levy. Anybody else? All right, thank you so much.
All right, so now we'll talk a little bit about the appeal procedure, and then, like I said, later we'll talk about some examples of appeal decisions from DPI, so you can kind of see what issues they key in on and what is basis for overturning an appeal expulsion decision. There's not much content to this slide. I'll kind of fill it in. We just had it kind of as a placeholder to flag for you that there are appeal rights. Normally that would be noted in the expulsion order. Parents can appeal, and there's not a lot of process required. Parents don't need an attorney to do this. They can appeal to DPI, explain, the reasons why they disagree with the decision, and then DPI has 60 days to review the appeal and make a decision. DPI won't, conduct interviews. They'll really just stick to what is on the record. So that's why, in talking about the importance of the record, that's why it's so important. So DPI can either approve the decision of the board, reverse it, or modify it. I'd say modifying it is pretty unusual. It's normally either, yes, that expulsion was okay, or no, it wasn't for these reasons, which we'll explain. What happens if we lose an appeal? It's kind of, I don't know if all parents know this when they file the appeal, but the board can just basically redo the hearing following the correct procedures. I'd say not every board chooses to do that based on the circumstances. Sometimes the board says, we lost, and based on the reasons in DPI's decision, no, we're not going to bring this back to expulsion. Sometimes if it's a procedural error in the notice, the decision could be, let's bring it back for expulsion and just basically redo it following the correct procedures. As you will, and then while in that 60-day timeline, while DPI is reviewing the appeal, the expulsion order is enforced in the meantime. So whatever the terms of expulsion that the board decided on, that's enforced while DPI reviews it. I think the examples will show this, but I'll just note, and I think someone mentioned this before, that DPI really will look at procedural issues, not, fairness, was this too long, like did the punishment fit the crime type arguments, really more focus on procedural arguments. And DPI can and does, and you'll see this in the decisions, on its own flag issues that were not raised by the parents on appeal. So before we go into expulsion appeal decisions, I was just going to give some background information from the board on, it looks like there's a question. I'll pause.
Sure, go ahead, Vice President Levy.
Can you repeat that last part? You're saying like under appeal, the parents may point out one thing, but if DPI finds other violations of appeal?
Yeah, so you'll see when we get to the decisions, like there's one where I think the parent in their appeal really just focused on more of a fairness, like my child didn't deserve this expulsion. And DPI said, no, we won't look at that. Our review is limited to procedural things. But in reviewing the record, we noticed that the notice of expulsion hearing was deficient for these reasons, even though the parent didn't raise it on appeal. And I think one reason DPI does that is that all families, might not, like I said, you don't need a lawyer. All families might not know kind of the technical procedural aspects, so DPI will look at that at the record for those things, even if the parent doesn't raise it.
Anything else, Vice President Levy? All right, thank you very much.
Alana, do you want to add on?
I was like, where's this coming from?
Ominous person here. There was a question earlier, just for, I think it was about the process and procedure for when the pre-expulsion doesn't go right? And then something wrong happened and it kicks back. That situation is not mirrored in the after expulsion process. So you'll note, I think, in the statute that it's a parent or student may appeal, right? So if administration's sour about something, they're not going to have the platform to appeal, just for clarification.
Yeah, and then it can also go to circuit court, like either party can then appeal DPI's decision to circuit court, which is unusual, but we have seen that happen. Okay, so I'm going to do my best to just kind of give, in a nutshell, special considerations when disciplining students with disabilities. And I know, I don't know the knowledge kind of every board in I feel like special education, Missy, you can identify with this, is heavy on acronyms, and I'll try and kind of stick to a high level background overview, but I'm happy to answer questions on any of it, as I'm sure Missy is too. It's kind of similar to the notice discussion we've been having, that even if the board isn't the one, board members don't sit on children's IEP teams, and it's, on federal and state special education laws, the law is pretty clear that school boards don't, it wouldn't be appropriate for school boards to second guess or overturn IEP team decision. But it's kind of similar to the notice discussion in that from a procedural aspect, when we get to a hearing, something that we'd want to get on the record is just making sure that the administration has followed the correct procedures and it's appropriately before the board for expulsion. So the disciplinary removal of a child with a disability triggers certain procedural requirements that are very technical if the removal constitutes a change in placement. And there's a change that it's very nuanced, what is a change in placement, and I could go into all that, but I think for our purposes tonight, what is most important for the board to know is that an expulsion is a change in placement. And long-term suspensions are as well. It's basically, there's like a 10-day rule. If it's consecutive, that's easy, but there's sometimes where if there's a pattern, we have to add short-term removals and see if that 10-day rule is met. So for our purposes tonight, no, when I'm talking about change in placements that triggers these procedures I'll talk about, an expulsion would satisfy that. So if there's a change in placement, like an expulsion, and that would be an expulsion recommendation. So when the administration knows we're going to recommend this for expulsion, that's when the IEP team would get together, meet. And does everyone, should I explain what an IEP team is, or is everyone comfortable with that? Explain? Okay, I didn't know if the thumbs up meant yes, explain, or no. Okay. So the IEP team gets together and conducts what's called a manifestation determination review to determine whether the conduct subject to discipline is a manifestation of the child's disability. And C, that describes the standard that the IEP team uses. So the next page talks about options. So if the conduct was a manifestation of the child's disability, then here's the procedures the IEP team has to follow. The most important thing for the board to be aware of is the student can't be expelled for that conduct. There's other things, the IEP team has to do in terms of behavior intervention plans. There could be a change in placement, for educational or FAPE reasons, but we wouldn't move forward with expulsion. So that's why not every case will get to you as a board on expulsion, because if it involves a student with an IEP, it might be a manifestation of the student's disability. I think, like I said, in terms of behavior or plan modifications or placement modifications, hopefully that the troublesome behavior is still being addressed one way or the other. Sometimes there's a misconception out there that and sometimes we hear this from other parents of other students, well, nothing's being done because this student is a student with a disability. And I think there's another process for addressing that conduct then. Pause for a question.
Oh, thank you. Go ahead, Board Member Delgado.
So what happens if, let's say that this is a child that has been struggling for a really long time, but an IEP has never been recommended for a child? Can there be a process where maybe an IEP can be looked at based on the behavior or maybe recommendations from, I don't know, a social worker or something within the school to get this child maybe getting the assistance that they need through an IEP, and then for that, maybe not undergoing that expulsion?
Yeah, so a couple of different options. I mean, one, just in a very broad sense, the school district has this child find obligation for, yes, parents can refer a child for a special ed evaluation, but the district also has this affirmative obligation, if we reasonably suspect a child has a disability, to refer the child for an evaluation. So sometimes I've seen that come up, and I'm sure Missy has in the context of discipline, when, let's say, a student's being referred for a pre-expulsion hearing and someone's looking at the record and saying, geez, there's a lot going on, with this student, and combined with information from the parents, let's kind of pause on the discipline side of things, do a referral, do an evaluation, see if the student qualifies, and then kind of decide what to do. And then on kind of the back end of things, there's a attachment, I want to say it's attachment 5 maybe, I have it somewhere in my notes, that talks about those kind of 11th hour referrals that, let's say, right before an expulsion hearing, or sometimes even at an expulsion hearing, parents will share information that, let's say, at the hearing, when it's the parents' turn to talk, they say, well, actually my child was just diagnosed with anxiety and depression, and I think really that's where the behaviors are stemming from. There's different options how to proceed. I'd say typically when we're all sitting at the hearing, the board would generally proceed and then handle the special ed side of things and see if it, makes a difference. But if we have some lead time on that, oftentimes we'll recommend, that's one of the few situations, going back to our discussion of extending timelines, where we might want to agree with the family. We'll hold the expulsion hearing in abeyance while we conduct this evaluation, and then would do a manifestation determination. In the meantime, in exchange for that, you agree your child won't come back to the high school, for example. We'll educate your child, off-site or by sending packets home, whatever is agreed upon. So yeah, the answer to your question, if I remember how it was phrased, is yes, that is something we should be looking at.
Yeah, so you did answer my question, but this is just going to go towards the school district and administration, that I really hope that that's a process that is taken in consideration before it even gets to administration hearing, that something has been done to make sure that that child, it's not going through maybe some disability issues where maybe even the parents are not aware of, that maybe the school district would identify much easier than the parents.
Thank you very much, Board Member Delgado. Vice President Levy?
Yeah, can you speak to the lawyers, to the, when the notice or need of a referral for IEP comes up at the discipline process? I mean, the student has been in school for how many ever years before. The district does have a child find responsibility, but there's also a portion where discipline and referral for IEPs comes up as a legal tactic also, which is not necessarily always a special education or a learning issue. And then secondly, are you also going to address change of placement for 504 plans and the manifestation determination review?
Yes, so I'll, for your first question, yes, I think that's why, on a case-by-case basis, we would determine how to proceed if we get a referral when discipline is pending. One factor that would come into play is sometimes how far are we at the hearing, Or is it the day the notice went out where we have kind of time to figure out what to do and possibly do an expedited evaluation and put the hearing on hold? Who's referring? Is it from the family, or is it something the district noticed, that affirmative obligation when someone was reviewing the packet? I'd say why we typically would, if we have the time, we typically recommend, and in that legal update that's attached, it kind of goes through the options, but typically what we recommend is putting the hearing or discipline on hold and doing an expedited evaluation, because we're probably going to do an evaluation anyway. It would be pretty unusual, and we'd have to have a good reason not to do an evaluation requested by the parents. So as to not, I don't want to say waste the board's time, but not get everyone together for a hearing that might then kind of be moot if the child qualifies and it's a manifestation. Sometimes it's just better to put pause on the hearing, knowing that the student doesn't necessarily have to come back to school in the meantime, get the evaluation done, and then decide if we can appropriately proceed with expulsion. The last thing I would say too, I think this is in the legal update, there's kind of some technicalities about when do we have to conduct a manifestation determination if the child wasn't identified at the time of the conduct. So I'm happy to go into that if we want to, but it's kind of different in every situation. But I think what's important for the board to know is that when it does get to the board for an expulsion hearing, one thing we would typically get on the record is we wouldn't recommend the board, see a copy of the IEP or manifestation determination paperwork, because remember Sheila was talking about, don't get into discussions about disability status, but something on the record where the administration says, this student is identified under the IDEA, and manifestation determination was conducted on this date and it was determined it was not a manifestation of the child's disability. Then to answer your second question about 504, I don't believe this is in our materials because we focused on IDEA, but there is, not in the regulations themselves, but the Office for Civil Rights kind of read into the regulations a manifestation determination requirement. So for 504 students, we also conduct manifestation determinations, except there's a very narrow exception. It's kind of interesting in the regulations that says for students who, I'd have to look it up, like possessed and are currently using illegal drugs or alcohol, you don't have to do the manifestation determination. Not all districts take advantage of that exception. Some just across the board will do manifestation determinations for all students with 504 plans or IEPs. And the last thing in terms of services for students, so I'll skip to, okay, so if you go to F then, yeah, so if for students with IEPs, if the team determines the conduct was not a manifestation, you can go ahead and expel, but we have to provide services, and the statute explains, oftentimes it's not the same level of services, and obviously it can be off-site, but services that still allow the child to, make progress on IEP goals and participate in the general education curriculum. For 504 students, you do not have to provide services unless you provide services for students without disabilities. So under 504, it's more just like a anti-discrimination equal access standard. So that's one thing to discuss, when you're talking about, precedent or what are we going to do for students. Under 504, it just is a matter of what do we do for students without disabilities? And then you want to make sure it's commensurate with that.
Right. One of the things that in asking those questions that I wanted you to explain is, one, there's a regular student with a 504, student with an IEP, that the regular education student has, less procedural legal rights, but that 504, the IEP dictates that, that when it comes to placement, those things, they've got more rights than the regular student. And then secondly, even as we discuss these specifics that are very narrow and drilled down, this is usually the work of the administrative team, because the Board of Education is just sitting hearing the evidence, because we'd be expecting people to bring the case and the recommendation to us. So the things that we're kind of talking about right now is actually the work of the administration to do. It wouldn't be for the board members to figure this out individually in that manner. And then also, can you speak to, once, as we think about IEP teams, if it was not a manifestation of the student's disability, and the behavior is expellable and the board decided to expel, that at that point, the administration would decide, since we still have a legal responsibility to provide services through the IEP, it's just not a team process anymore. It would be the district deciding this is the service we'll provide to meet our obligation.
Yeah, so for the last question, the IEP team would then meet to determine what services are we going to provide. It's still an IEP team decision because the team would want to take a look at what do we need to provide FAPE and all of that. I'm trying to work backwards through the other questions. Yes,
Right, but with the IEP team, when the parent is saying, yeah, for FAPE, they need to be in the building, not out of the building. But it becomes a unilateral decision for the district at that point of the team?
Did you want to chime in, Missy?
I'm just confused.
I think the IEP team has a lot more flexibility. When a student's expelled, we can provide services, but the law is pretty clear. It does not have to be on site. So the IEP team would be taking a look at what does the student need to still make progress on IEP goals, even though they can't come in our building anymore. Is that, okay.
It's still a team decision.
Yeah, it's still a team decision because it might be, are we going to offer, tutoring? Are we going to offer placement at this alternative facility? Is it going to be virtual and they won't be with groups in a virtual setting? It'll just be one-on-one. I mean, there's a lot of flexibility, so that's why it's still a team decision, but within certain, parameters set out by the expulsion decision.
Are you good, Vice President Levy?
Okay, so just seeing, and so E I haven't mentioned yet. Just wanted to note it for the board so you're aware. We're talking about the obligation to conduct manifestation determinations. In certain limited circumstances, certain drug or weapon violations or serious bodily injury, and I would say DPI has set like an incredibly high standard for what constitutes serious bodily injury. If you look it up, it's like someone has to be maimed or loss of a bodily member. I mean, it is it's pretty high bar. Then unilaterally, the administration can decide to remove the student for up to 45 days to an alternative setting. The IEP team would still determine where that setting is and what services the student would receive, but we have a lot more flexibility to and sometimes it's just to get our ducks in a row in a little bit to decide, if there's a serious weapons, drugs, bodily injury, those are all pretty serious circumstances. It gives the district more authority to unilaterally remove the student while kind of figuring out what to do next from either a discipline or a IEP team decision-making standpoint. So that's a helpful statutory provision that the administration can take advantage of. So now in the remaining time, I'm going to talk about some recent expulsion appeal decisions. So to give the board an idea of what types of issues are leading to appeal and then what DPI is flagging, we just pulled a handful of the most recent expulsion appeal decisions. So these aren't necessarily the landmark decisions, just the most current, so you can kind of see the trends. So in the first one, we just included quotes, just a snapshot of what was in the DPI decision. This is one where you can see the parents tried to argue kind of a fairness argument. We're saying the parents said their child was used as a scapegoat to appease the victim and that other students who also bullied the victim were not subject to expulsion. And DPI said, when we're looking at expulsion appeal decisions, we're not going to look at what discipline was or was not issued to other students. We're looking at this on a case-by-case basis, and the treatment of other students isn't relevant to DPI's review of this appeal. However, we just added a caution just to flag this, because even though on expulsion appeal decisions, DPI won't look at treatment of other students, in other contexts, like we were discussing before, disparities in discipline might be very relevant to a DPI review. So for example, in the context of a 118.13 discrimination complaint, you can see we quoted from a recent DPI decision. It was on, the complaint was based on racial discrimination, and DPI reviewed disciplinary records, looked at the discipline issued to student A, compared it with discipline issued to other students who were similarly situated, engaged in similar conduct. And so, like we were talking about before, you know, OCR and DPI will say if there's statistical, you know, disparities in discipline, that kind of raises a red flag. It's not on its own discrimination, but then the district has the burden of showing legitimate non-discriminatory reasons for that difference in discipline. So for example, like progressive discipline, let's say one student had a disciplinary record or had, you know, a behavior contract resulting from a pre-expulsion hearing previously. Or, you know, let's say, I think one example was used about one student possessed drugs, the other student was dealing drugs. So, you know, yes, we want to look at that data, and DPI and OCR will in certain contexts, but the district still has that opportunity to explain, no, here's why there was different discipline issued. Okay, so the next one, this one goes to our discussion about introducing evidence at the hearing. So it's just talking about how basic fundamental fairness and ideas of due process, that requires evidence that's going to be relied upon by the board, or in this case, an independent hearing officer, be introduced at the hearing so the family can respond to it. And in this case, there was a video of an incident that the hearing officer watched prior to the hearing. The video wasn't shown at the hearing, wasn't included in the expulsion packet, and wasn't part of the expulsion hearing record, and the hearing officer didn't really have a good explanation for why they viewed it in advance of the hearing outside of the presence of the parties. And DPI pointed out there was disagreement on what the video would have shown. The parents said it didn't show something, administration said it was, so DPI said for due process and fairness, that video should have been introduced because it was relied on as evidence for the expulsion. And yes, that's all on that one. Okay, so then the next one goes to the importance of the notice. And this, I would say, is one of the most common things that comes up about notice on appeal with DPI these days, is just how the notice has to state the particulars of the alleged conduct upon which the expulsion proceeding is based. So in this one, you can see that DPI said the notice was deficient because the notice just said the pupil engaged in expellable conduct by intimidating a witness, assaulting another student, and violating existing pre-expulsion conditions. And DPI said, and there's many decisions before this one that say this, that in order to be an adequate notice, we have to inform the family of the time frame. So we normally say like on or about this date, this conduct occurred, during which the misconduct occurred, where the misconduct occurred, and typically, you know, we would say like on school grounds, because that's pretty key to the statutory basis too, or off school grounds, wherever it was, and a description of the conduct to be considered. So we have to give that reasonable specificity so the family knows, like, here's what we should be prepared to respond to, and here's what the student is alleged of doing. And so that's something, and I know you're going to go back to talking about the notice in a bit, but something, even though the board's not involved or presumably maybe won't be involved in doing the notice, in doing the expulsion hearing and reviewing it in the packet, these are things you can look for as board members, and in deciding whether to expel the student, you know, tying the deliberations back to what was in the notice is appropriate for the board. The next decision, a few different things to point out. There's a lot going on in this one. One, this is an example. See the first sentence where it says an issue not raised by the appellant, so not raised by the parents, must be addressed. So it's just an example of where DPI on its own initiative flagged something. One was kind of, my guess would be a copy and paste error, or, you know, a template that wasn't changed, but findings of fact said the pupil appeared at the proceedings even though the student was not there. So just a good reminder to make sure, you know, we fly spec the order before it goes out and make sure everything is accurate. The more significant issue, this goes back to that weapon discussion we were having. So remember we talked about how the firearm, in order to be that mandatory expulsion, has to meet the definition in that federal statute of a firearm. In this case, it was a BB gun, and in DPI reviewing the record said everyone agreed at the hearing it was a BB gun. And the administration, in presenting its case, said, you know, we really don't want to be here. We didn't want to take this one to expulsion, but we have to by law. The board, that came up in board deliberations where they said, well, we have to do this. And so read the bottom paragraph, DPI said, based on the board and administration's apparent misunderstanding and misapplication of that statute that we were talking about is a significant mistake of law that can't be separated from the board's expulsion order and irrevocably taints that order and therefore reverse the expulsion. So that's an example of where, on the front end, when relying on that, it doesn't mean for other statutory reasons it couldn't have gone to expulsion. If we concluded a BB gun, endangered the health, property, or safety of others, but just relying solely on that statutory basis, and then that discussion of everyone kind of agreed they wouldn't be there if they didn't have to be, when in fact they didn't have to be, DPI reversed that decision, and then it goes back to the district to decide, do we want to redo the hearing on other grounds or just let that one drop because now we know we didn't have to do that. And then the last thing I think I wanted to point out is, attachment number 6 in the outline packet is just a legal update we sent out of 2 expulsion appeal decisions that upheld expulsions based on threats outside of school. Just wanted to point these out because, one, I think these are getting to be more and more common, especially with social media, where we're getting threats of school violence and it's not on school grounds or using school resources. And then, in light of national events, with a lot of times what we've seen is when there is, a school shooting, sometimes you'll see follow-up threats, like one of the cases here, a student days after the shooting in Parkland, Florida, posted something on social media saying like Parkland 2.0 coming soon. So we are seeing more of these. And these were kind of unusual facts. In one case, it was over summer break and the social media post was deleted by the time school started in the fall. In another case, the student was actually enrolled in a private school at the time of the social media threat, then transferred to the public school. In both cases, like after the fact, it got reported to the public school and students perceived it as a threat. And the expulsions were upheld, and DPI looked at things like, was it reasonably perceived as a threat by like school staff or students? Took a look at, in both cases, that threat wasn't limited to like a specific school or date, so it was kind of an open-ended threat. And took a look at like student staff reactions. It wasn't any like disruption caused to school to show like it was actually taken as a threat because school was, canceled one day or, law enforcement was involved. And so those are kind of the factors. Oh, and then national events, DPI said, in light of national events, obviously schools are taking those very seriously. So it's just a helpful decision, or 2 helpful decisions kind of upholding board authority in those situations.
Thank you so much.
3 hours, I thought we would never fill 3 hours, but we, the last thing is the board concerns. We were listening, and I had jotted notes from the earlier board meetings. And I know that these have been interwoven, so I'm not going to, on the consistency, I would like to say, I think if we put systems together, notices, procedures, scripts, that can really help. If as many board members can come to the meetings as possible, I recognize scheduling is a challenge, that's B. But the other I would say is that the board is statutorily obligated, and when the board takes action, if a quorum of the board is there, that action stands as a board action. And there's a lot of things we can do together to make sure that the decision-making of the board is strong, consistent, legal, well-founded, that type of thing. So you've heard a lot about consistency scheduling. That's going to be a challenge, and I think it's got to have a system where you guys have a good system in place where as early as possible you can get those dates and there can be multiple options. And then support for parents and students, that's been on the radar screen, and we have a system, I think, in place. We know that's a priority of the board. Timing and distribution of materials to board and parents, that was discussed. We want to make sure that's consistent with due process, so at the same time, at the beginning of the hearing. And then support for the board, that's where a lot of the things we put in place suggested can really help a lot, and that's form, scripts, guidelines, legal support. So those are some of the concerns that the board had, and we tried to address those in the outline. And it's 8:28, and I know you have some other discussions you want to do, but that completes our presentation.
Well, I want to thank each of you so much for putting together this extremely thorough, wonderful presentation. And thank you so much, Ms. Beavers, for being here tonight and helping address all the range of considerations. So thanks for that. I want to check in with the board. I know we started a little late, and I know we took a brief recess. I have a couple of different action items that I've been jotting down for consideration, and I want to check in. Dr. Kieser and I are prepared to include an action agenda item on the 3rd if we want to just summarize actions that we need to take some time to deliberate, and then bring this back so we're not squeezing action in the last few minutes of a meeting. But if somebody feels really strongly otherwise, I don't want to cut anybody off. So just want to kind of check in. I'm going to summarize back what I've written down. Please definitely jump in if I overlooked anything. And then my recommendation at this point would be to, once we kind of summarize that, adjourn and then bring this up again on the 3rd to take formal action on the process going forward. So what I have written down is that we need to take action on the notice of hearing details, including kind of like clarifying those roles. The role of the district counsel, if we want to formally make a motion that we want to have, legal counsel at, X number of meetings or for a certain period of time, however we want to do that. There was a recommendation made based on Board Member Delgado's concerns to include like after 5 p.m. or whatever, a time in our action language. So I don't want to lose that. We have a decision to make regarding the question regarding recusal. Does that get brought up at the time of the notice in order to avoid scheduling conflicts, which I think was also Board Secretary Shope's concern, if we only have 4 people available and then somebody has to recuse, or how we roll that out. I know there are a lot of opinions on that. And I think actually, sorry, those are my own notes. I think that's everything I wrote down for action. Did I miss anything? Jump in, go ahead.
I would just like to be clear on how we will be collecting data moving forward. Thank you again, Ms. Beavers, for letting us know that some data is already collected so that we can refer back to that for consistency. Again, understanding that each case is unique. And then is it a given that as a part of the structure that the administration will provide expulsion recommendations to the board at the hearing? If not, I would like to request that.
Perfect, thank you. So I've written down a piece about data collection moving forward so we can kind of self-evaluate, kind of embrace that continuous improvement mindset. And then administrative recommendations. Is there a better way for me to phrase that?
I think that's perfect.
That's good, okay.
If it's understood that that would be a part of the expulsion hearing, if not, I would like to request it.
Perfect. Anybody else? Is everybody okay with us taking a minute and then taking action on everything that we just kind of summarized back at our business meeting on the 3rd? Go ahead, Vice President Levy.
All right, you ran down an agenda, and this might seem long, but just kind of, are you going to, from that agenda that you ran where there's kind of some decisions left or right, are we all going to take one kick at it and tell you where we're at now, and then we're going to vote on the 3rd, or what are we doing?
I mean, if you'd like to kind of round robin our opinions, that's fine. I think, I guess what my intention was in bringing it up is just kind of asking if, since we were scheduled till 8:30, if we could maybe just adjourn and then revisit the discussion on the 3rd.
Will this list be printed again I know it's summarized. I just watched the meeting. Okay. Yeah, I can be easy tonight.
Are we good? We're good? Okay, I missed the last thing you said. Okay. Does anybody have an issue with putting it on the 3rd? John, did I overhear that you're not going to be here the 3rd?
That's correct.
Do you want, is there a risk or hazard in doing this on the 17th in terms of, I know summer school is done on Friday. Thursday, just kidding. I knew that because I have children. So summer school is done on Thursday. So I'm assuming we wouldn't have any expulsions between the 3rd and the 17th of August. Does anybody have an objection to taking formal action on this on August 17th? Okay, so then we will kick that to the 17th because we want to make sure we're inclusive of everybody, that everybody can be present. Go ahead.
Would it make sense just to have a discussion item on the agenda, just in case people have updated questions or need clarification, so that on the 17th, we're prepared to be efficient?
I fully support that. All right, sounds good. So Dr. Kieser, are we good with that? Okay, so we'll put a discussion item in the third, action on the 17th. Before I get you, Vice President Levy, that work for you, Ms. Beavers? Does that work for your process? Okay, great, perfect. Go ahead, Vice President Levy.
No, I was just seeking clarification. So we'll kind of talk about this on the 3rd and then vote on the 17th?
That is the plan, yes. All right, sounds good. If there's no other board business, can I get a motion to adjourn, please?
So moved.
Second.
Any discussion? I would just like to point out that we are adjourning at exactly 8:34, which is exactly 3 hours after we began. All in favor, please say aye.
Aye.
Aye. Aye.
Aye.
Aye.
Any opposed? Have a beautiful evening, and thank you all very much.
Thank you all. You were so thorough and so helpful. Much appreciated. I really appreciated all the questions. It was good questions. We do our best.
Good seeing all of you in person. And hello to everybody who wasn't in person. Yeah. Good to see you too, man.
Absolutely.
You think it was what you wanted and was helpful?
Yes. And we have a lot of those ads that never, what we're missing.